But, may I mention one urgent matter for upgradation in the daily?
Upgradation, please hand
Your
over the
Lordship.
slip mentioning the urgent.
Your Lordship, if may I mention.
Please wait. Please wait. Upgradation, please hand over the slip mentioning the urgency.
Upgradation matter.
Please hand over the slip.
Tomorrow.
Please mention the urgency. Hand over the slip.
My lord, kindly allow me, my lord, to verbally mention, my lord, item number 140 for upgradation. My lord, the matter has been, suit has been instituted before a quorum non-judice. My lord, the valuation of the suit should have been, my lord, more than a crore. My lord, showing that it's a 200 rupees suit. My lord, a suit is filed before, my lord, civil judge junior division. Injunction obtained and then, my lord, adjournment is being taken.
All right, please hand over the slip. Yes.
Lord,
Hey, fixed period at any time subject to my lord. So there is
Yes.
Your,
my lord, 20 the next date before the
21st. You have indicated in the
that I have indicated.
highest to US husband single class 12 Lama
government does not pay money. There are provisions.
there are orders charging 2 crore rupees a year.
Chakraborty, there are procedures for that.
It was
Apply
hard
for that.
for one day. Mr. Mukherjee, adjournment matter. She cannot get admission. The 1 lakh granted from the date of order, not from the date of application.
You must update us, please hand.
61 kindly consider, otherwise the government needs to turn.
Mr. Chakraborty, I'm considering all the slips. Please
The
go.
government needs to turn.
My matter is fixed on tomorrow, my lord.
Upgradation. Please hand over the slip.
your Lordship,
Lord,
if I may
item
mention.
71,
All three are urgent. Upgradation.
2 are expeditious and 2 are urgent matters.
So everything will be upgraded. No matters will be taken up.
Let the
Your choice.
matters be upgraded.
I will upgrade all the matters.
Your
Lord,
Lordship,
item 7,
It will happen.
Lord, items
You-
If you cannot choose amongst which of the matters are most urgent, you hand over the slip. I will upgrade all the matters. It will be the same thing.
Lord, Lord, one
Your Lordship, if I may mention a matter, Your Lordship, an order dated 25th August,
What, madam?
the ground for urgency is that
Please hand over the slip mentioning the urgency.
My lord,
Lord,
extension of interim.
Extension of interim order. Please hand over the slip.
Lord, item 71 eviction will be done.
Chakraborty, please wait.
Restoration application.
Applications, extension of interim order. Extension of interim order. Applications, please hand over the slip.
Urgency, application.
Urgency application. Restoration application.
Any application, please hand over the slip. Any section 24 CPC matters?
Restoration application.
Section 24 CPC.
Restoration.
Section 24 CPC, please hand over the slip.
In the list, my lord, on 15 May, my lord. My lord, I have already handed
Yes, non-prosecution, please hand over the slip.
I have already handed over, my lord.
151 it's of the monthly list. You are for the petitioner. 151 here order record করে দিন তো।
My lord, I have a matter to be mentioned, my lord, for enlisting.
Actually, please wait. For release. To be mentioned for release.
My lord, I have
Mentioned for release. To be mentioned কালকে দিয়ে দেবেন।
my lord, I have already handed over. My lord, kindly give me leave to mention, my lord.
Yes.
The section 24 application is pending before the
Section 24 of what?
my lord, plaintiff has filed the recovery of position.
Section 24 of which?
My lord, transfer of the case, my lord. Another court.
Section 24.
I have already handed over my slip, my lord. Kindly, my lord, give the direction to appear on 15 May, my lord.
I do not have determination. I will have to release this. That is,
My lord, may I be permitted to mention a matter? My lord, it has become infructuous, my lord. Infructuous, my lord.
yes,
Lord, item 71, there is an order passed under section 14. The CJM, Lord, authorize the office or the bank to take over possession.
70,
Section 4, item 71.
yes,
Lord, we challenge the DRT passed order in our favor, citizen order.
Yes.
DRT order saying that from the record it did not appear to the chairman of the DRT that the lawyer is the bank's lawyer. We have annexed the section 14 application where the bank's lawyer with the involvement that Bhattacharya was the bank's lawyer who has been authorized to take over possession. 71, that they may take over possession any day.
please for the bank,
That I need to inquire. I don't know that.
please mention tomorrow. Please start the mention.
My lord, if you file without a certified copy,
What is the extreme urgency?
well, the urgency is that the tribunal has passed direction on us, it's in excess of its jurisdiction, my lord.
Please file with the certified copy.
My lord, kindly,
No, no, no.
my lord, we have to file, otherwise the arbitral proceeding will go on, my lord, if they.
Please obtain the certified copy, then file.
My lord, may I mention one matter for inclusion with this, my lord?
Inclusion,
Your lord,
please hand over the slip.
your lordship, may I,
Permitted for restoration.
Inclusion, please hand over the slip.
your lordship, may I permit to mention one matter
My lord,
for upgradation, your lordship?
Please wait. Upgradation, please hand over the slip. I have said, please. hand over the-
Restoration.
My lord,
Lordship, can you allow me to mention one matter, my lord? My lord, regarding item number,
Of administration proceeding. That I have been directed.
What do you want, Mr. Banerjee?
That it is fixed on 19th, my lord. I have to pay 1 crore 60 lakhs as indemnity bond.
Pay that.
But the consentees are agreed to the grant of probate. But the grant should be there.
Where it is appearing in the monthly list.
No, it is not there in the list. We have filed yesterday.
You have filed yesterday.
But 19th, it was.
What is the date mentioned in the presentation form for enlistment?
16th, my lord.
Will-
But on-
Here, Mr.
but
Banerjee,
on
please wait till 16th. Then mention if it does not appear on 16th.
That will be the last date, my lord, before
Mr.
16th.
Banerjee, it can't be held. The date we have mentioned in the presentation form, it will be.
But that was that was due to, at the time of filing, 48 hours has to be.
That has to be given.
But I have given notice to the caveator also.
Maybe, yes.
your lordship,
But kindly enlist it on 16th only. But at a position so that it can be reached.
Mr. Banerjee, have you seen any matters in which you have mentioned in the dates in the presentation form, it has not been listed? Please give me one instance.
But it should be.
Please wait till 16th. If it does not appear, please mention.
But it will appear, but in a position, it should reach, my lord.
Please wait. Let it appear first. See if I can reach or cannot reach.
Or we have to mention on 16th.
That is up to you.
But we will.
your lordship,
item number 132 of today's list, madam, kindly take this matter, otherwise matter
130.
32.
What is the urgency?
It is a suit for eviction, my lord.
Why do you want it to be taken up today itself? What is the grave urgency that you cannot wait?
No, my lord, the judgment date of judgment is 22nd May.
Judgment will be delivered on 22nd of May. What is the order impugned?
Close the evidence of the DW1. I am the
132.
DW1. Yes. I am the dependent, my lord.
132 কালকে 2 PM করে দিন।
my lord, may I have the liberty to mention item 121? I would not have otherwise bothered your lordship with
Yes.
the prayer for upgradation. My lord, Vishal Megamart on VIP Road, 40 lakhs rent, my lord. Since 2020, nothing paid. My application for summary degree.
Please
the
hand over
one-
the slip mentioning the urgency. Yes.
My lord, I have
your lordship,
Please hand over the slip.
20 crores and odd is, my lord. Kindly, my lord, I know money may not be, my lord, a ground of urgency, but my lord, I am suffering, my lord, daily, my lord, because.
Let me see.
Your
Not
lord-
to consider the
I
inter.
have a matter to be mentioned, my lord.
Charge at the last paid rate, my lord.
Consider the
I
inter.
want to mention matter, my lord.
Otherwise,
for
I
enlisting.
will upgrade all the matter.
Take only 5 minutes, my lord, occupation charge at the paid rate.
That's not the.
Kindly allow me to mention a matter, my lord.
It will take 5 minutes.
My lord, the company will go into
Mr.
liquidation. my lord.
Dotto, all of mentioning for upgradation. If 5 minutes are given to all, kindly see.
your lordship,
23rd, I will.
I'm in the online, my lord.
The slip.
your lordship, kindly allow,
No, this is a matter to be mentioned before your lordship, my lord.
Your lordship, kindly allow me to mention one matter regarding item number 226 of the today's list.
What do you want?
My lord, kindly fix this matter, my lord.
Upgradation. Please hand over the
No,
slip.
my lord, this matter is fixed on 19th Monday, my lord. And PW1 cross-examine has been going on, my lord. Evidence
Mention
has
that.
been. Well, kindly take this matter, my lord, otherwise I will suffer irreparable punishment.
Mention that, hand over the slip.
Item number 30.
My lord, kindly fix.
My lord, my lord, I have a matter to be mentioned, my lord.
Yes,
This is for inclusion of the matter, my lord.
yes,
I
please.
have mentioned in earlier occasion, my lord, but the matter is not listed yet.
Yes, please, allow the, yes, Mr. Bagchi.
I will go to court and thereafter I will hand over. Item number, there's no, CO number 1594 of 2024, my lord.
Hand over the slip, sir.
Okay, I will go to the court and thereafter I will hand over.
My lord, may I have your lordship's kind leave, my lord?
1594. CO number 1.
Please hand over the slip. Repeatedly.
My lord,
Okay, I will go to court and thereafter hand over. Kindly allow me CO 1594 of 2024. This is a short matter, my lord.
Yes,
I will
Mr.
hand
Bagchi.
over.
Yes, Mr.
my lord,
Bagchi.
I would not have, my lord, bothered your lordship for an upgradation, my lord. I have mentioned this matter three
Yes,
times,
my
my lord, before your lordship. The petitioner is an octogenarian senior citizen, my lord. There was an application under section 10 of the CPC for stay of suit that was turned down by the trial court. Self-same application based on the self-same cause of action was once again preferred and it was allowed, my lord. Preferring that, my lord, I have challenged before your lordship.
Advocate on record to hand over the slip mentioning the urgency. Yes.
My lord, I've done it for the last 3 times, my lord. Kindly consider, my lord.
I have to consider the inter se urgency and I have to upgrade. Otherwise, all the matters
But that is why I had verbally mentioned it before your lordship for today, man.
will not improve because I have to consider the inter se urgency. Otherwise, I have to upgrade all the matters.
My lord,
Inter se urgency, Mr. Bagchi.
well, that is what I had stated, my lord, for the last 3 times, my lord. That's why I verbally mentioned it.
Consider that.
My lord,
Yes.
my lord.
What do you want? Yes.
Well, I am for the mother, Mala. But today let it be, Mala, because tomorrow is a visitation date, Mala. And Mala, now the vacation is also, Mala, has started.
It's appearing.
Mala, it's appearing another 302.
302. But a Calcutta to be mentioned.
My lord, kindly
You
take
mentioned
this matter,
tomorrow.
my lord, otherwise I will, so my lord, this is the.
Please hand over the slip, madam.
My lord, this is appearing in the list, my lord, 226 as the upgraded matter, my lord. But my lord, if it will not take it, my lord, I will suffer, my lord.
Madam, I've heard it. I've heard you. Yes.
My lord, I have already submitted the slip for upgradation, but I just want to say something that for
All
8
right.
months, husband is not
All
paying
of
the
you
maintenance to the wife.
individually.
If you
Yes,
please
I'll start from here. Yes.
Lordship, I was only,
Mention. Yes.
Lordship, I was.
Yes, Mr. Bandhavata, do you have anything to submit? All right. Yes, yes, I will hear all of you on urgency. Want
Your
urgency?
Lordship, only one thing, your lordship, it was mentioned twice last two witnesses, your lordship. The application or order 7 rule 11 pending from 2020, your lordship.
Hand over the
Lordship
slip.
and property of
Hand over the
property has been injuncted by city court, your lordship.
All right, hand over the
My
slip.
lord, execution.
Yes, Mr. Ganguly.
And the other answer is consistent completing. Lord, I mentioned twice, Lord, kindly take it up on a take or video.
Hand over the slip. Yes,
In a suit for eviction, Order 39 Rule 7 was allowed, where a non-suited property has been incorporated. I have challenged this order, but 16th, the commissioner appointed, given notice, the 16th, the commission work will be held. I have annexed the notice, my lord.
hand over the slip. Yes.
I have written the urgency.
Have obtained an ex-parte identity order of injunction was laid before the miscellaneous appeal. Should the construction work is going on. It's appearing as item number 56.
Hand over the slip. Yes. Yes.
My
Please
lord,
come in front. Yes.
My lord, may I be permitted to mention item number
Yes, yes, sir.
141?
Allow everyone.
My lord, the
Please mention
difficulty
orally.
this arises out of Public Premises Act. My lord, the appeal is pending from the 2015. All of a sudden, my lord, few months back, the estate officer has locked away the property which is in dispute, my lord, and my edible items, your lordship, perishable goods are there locked in the property, my lord. My lord, there is an imminent threat of, my lord, third-party litigations against me because I am unable to supply those goods, your lordship, all of a sudden without any, my lord, with the matter being
Hand over
sub
the
judice, your
slip.
lordship. This is the
Yes,
urgency.
sir.
Lordship.
My lord, my
Thank
item
you,
is 1135 in the monthly list. My ground of urgency is that husband is not paying the maintenance to the wife for the 8 months.
And in this case, mediation has been ordered, but no mediation has been taken place yet. If you please consider and update the matter.
My lord, execution pending since 2018, my lord. Upgradation items.
My lord, by challenging the honorable DRT orders, I have moved this CU application. Once the matter was appeared before the lordship, but anyhow, the matter goes out of list. My lord, the urgency is that on 19th, honorable DRT will dismiss my appeal, my lord. On that ground, I'm praying before the lordship to hear this matter in this week, your lord. Thank you.
Hand over the slip. Yes.
Since August 2020, an extension application is pending before the second court junior division barrack. Earlier, in terms of this order, I have served a copy to the opposite party.
Hand over the slip. Yes, Mr. Haldar.
The officials, it has not been yet.
Yes, yes.
My land has been encroached in trespassers and time of my father. They have till date not shown any title document in support and their claim is adverse possession, which is also barred by use. I have been waiting for a long time. I cannot enter my own land.
I think you have moved your matter now. So can I take up and pass the order now? I think you have exhausted yourself on the merits of the matter. Nothing more remains in the main matter. Hand over the slip. Yes.
I was kindly to mention this matter and any time today, my lord. My lord, my section 47 application has been rejected. The execution is scheduled to take place tomorrow, my lord. My lord, it's arising out of the eviction to have used the property. They have the police office.
Yes.
Court has granted my lord police assistance. Any time, my lord, today.
File it, it will appear.
My lord, kindly, my lord, the execution is supposed to take place
Maybe.
tomorrow, my lord.
Nothing will happen.
My lord, kindly grants me you.
There are provisions in the Code of Civil Procedure. If it is possession is taken up, you succeed. There are provisions.
My lord, kindly allows me to move
Please
tomorrow, my lord. My lord,
please
any
file.
time tomorrow, my lord.
Please file, it will appear. Yes.
I pay for experience hearing because of the fact that
Yes.
number one is 70. I as well.
Yes. Hand over the
I permitted to mention one.
Yes.
May I please, your lordship, my lord, item number 139 of
Sir Mukherjee, I am proceeding from this way. I am hearing all of you on the ground of urgency. Yes.
my lord, item number 139 of today's cause list, my lord. The next date would be for 22nd of May 2025, my lord, for cross-examination of PW1. Would your lordship kindly take it up? I'm grateful, my lord.
May I be permitted to mention one matter? Lordship, a suit for eviction has been filed. My 7th day application has been allowed of the plaintiff, and the matter has been fixed for evidence for cross-examination. And the matter is running in today's list under the heading motion. Lordship, may I be permitted to update the matter?
Your Lordship, this is expeditious disposal, NCLT filed in the month of January 2021. Several times hearing has to be done, but till now, they are not taking any action.
No. Please file with the sign with this certified copy.
Signed copies are not given. He communicated by email. I managed the email file. Please, the list of file without. I will serve the other side. I will communicate. So come and
Without the order, how can I decide that?
The Word document is there. He does not sign. He serves the Word document by email. That is the thing. I have annexed the email and the Word.
Have you stated that in your application that it has not been signed? It is only forwarded. Please state that in the affidavit, then come.
Lordship, may I permit to mention, Lordship, section. Lordship.
He's senior, I think.
Lordship.
Correction to be mentioned. Yes.
Lordship, section 24, Lordship, it's pending from the long time, Lordship.
24 of what?
Section 24 CPC, Lordship. Transfer of matter, Lordship.
Where it is appearing?
Lordship, yes. In the item number 1053. Monthly list of May 1053.
In the monthly list of May 1053 te একটা order record করে দিন তো monthly list for want of determination let the
My lord, may I permit to mention urgency is your lordship, my lord. The trial court closed my evidence, your lordship, because my application was for appointment of commissioner, your lordship. Your lordship heard this matter, your lordship. On 16th is a fixed for final argument, your lordship. My lord, if your lordship kindly take up tomorrow, your lordship, otherwise my application will be frustrated, your lordship. Kindly, your lordship. The 16th is the final day for the argument, your lordship.
Item number 142 in today's list, my lord. My lord, the problem is that on the 15th of each succeeding month of the West Bengal Premises Tenancy Act Section 1C has not been followed. My lord, only the 1 month, there is a delay of few days, my lord. The defense was strike down. My lord, kindly fix the date because, my lord, in the lower court below, my lord, the date has been fixed for the final argument. If the final argument has been taken up, my lord, kindly fix the date, my lord, before the vacation. My lord. That is my only prayer, my lord. I'm great.
My lord, may I be permitted to mention item number 1582 in the monthly list of May. There is an earlier occasion obtained an order for expeditious disposal in the suit number 1688 of 2022, but however, there is an unnecessary delay. So please upgrade this.
Yes. Rightly done. Rightly done. I'm passing orders now. No. Hand over the slip. Anyone for upgradation? Mr. Mukherjee, anyone? Any matter? Don't want to mention. All right. Half an hour gone. Yes. Call the list.
Item number 1.
All appear for the opposite party. Really?
Mr. Bhattacharya is absent.
Since I am not inclined to take up this matter on personal ground,
My lord, Mr. Bolalal Sahu is the advocate on record. Right now, this section 24. Section 24.
for want of determination, let the matter go out of list. Next. Yes.
My lord, item number 3. This is a matter that summons was not served, and my lord, summons not issued even, and the unissued summons are still lying on record, but the decree has been passed ex-parte.
Decree has been passed ex-parte.
Yes, my lord.
Yes. Then what have you done?
Therefore, thereafter, I filed an application for setting ex-parte within 30 days from the date of knowledge when bailiff came to the spot on for the delivery proposition. This is the date of my knowledge, and within
Order under challenge. 5th of
my order date 11th February 2025.
11th of
11th February 2025. Actually, no hearing was taken up.
what happened on 5th of March?
5th of March, my lord, the evidence started and it already closed. And my lord, 4th June is date fixed for.
No, in the miscellaneous case, did you pay for stay?
Yes, my lord, miscellaneous case. No, I filed the application,
Yes.
but that is one notice was sent, but the avoided survey again date is fixed for 30 July for awaiting SID in the meantime to take steps, 30 July. And my lord, and the application stay has been made in the existing case and stating that no summons served and not issued from the record. And my lord, on application that record may be tagged.
Miscellaneous case, you have filed an miscellaneous case under order 930.
Yes, my lord.
Did you file any application for stay there?
No, my lord, not.
Why?
But that is my omission and mistake.
Omission.
I shall file immediately, but
File.
my lord, 4 June.
Degree. What was the suit for?
My lord, I paid the entire amount of
What was the suit for?
suit for possession, recovery of possession, but my defense is that I paid the entire amount.
What is the extent of occupation you are occupying?
My lord, it is not eviction of tenant. I have paid entire money for and the defendant did not register the document as per request. And since
The
2000
different thing altogether. You are occupying, a decree is against you. Where is the decree? Show me the decree.
decree.
Yes.
Decree কোথায় আছে? Decree কোথায় আছে? ঠিক আছে। আমরা দিয়ে যাবো, ঠিক আছে।
Where is the application for stay you have filed in miscellaneous case?
Yes,
On which date?
that is at page 23.
Yes.
Also kindly can see also page 21 also.
No, you have not. This is a supplementary affidavit.
Hey,
You have
yes,
not
I
filed any application for stay.
yeah, but page 23. Page 23.
This is in title execution.
Yes, my
This is a
lord.
miscellaneous case.
That is true, my lord. But my lord, if it is
Giving you liberty to file an application for stay in the miscellaneous.
my lord, kindly consider. I can show a judgment if decree if this summons is not served, the decree is not at all decree. This is a judgment of Supreme Court. And my lord, I mean position 6.
You did not show judgment before the High Court for such proposition. That is well said. For that, Civil Procedure Code provides for filing a miscellaneous case under Order 9230.
Yes, my lord.
I'm aware of those provisions. It's not that. I'm asking you, did you apply for stay in the miscellaneous case, for stay of execution?
No, my lord, that is my mistake. But my lord, kindly consider, I filed in the execution and stated that no summons served can grant me stay. And my grievance is that no.
Summons served, that is on merit, sir. I cannot decide it here.
Hmm.
I cannot
So-
decide it here,
Hmm.
whether summons served or not served.
And my lord, the applications are not hard at all. There are also another grievance of me. Matter not taken up for hearing, but recorded summarily that the summons hard. And my lord, see the reason also, the no status report of the 542, but it was stated in that file application number, everything was stated in the application. Kindly consider, my lord.
Yes, next.
My lord, next item, I am also for the petitioner.
Four years.
Four.
That I mentioned, my lord.
Hey,
Kindly
four.
see there is a
Other
notice
four.
of caveat, my lord.
This is who is for the petitioner?
Yes,
Yes, madam. Why you did not? Yes, you are.
my lord. My lord, I had no knowledge about the case because my innocent.
You have no knowledge.
I had no because my lord, my clerk file he did not inform me.
Yes,
And
that's between you and your clerk. That's between you and your clerk. Dakan to na ke? That's between you and your clerk.
আমি ধ্যান করেন তো বলবেন না
Yes, now what do you want?
My lord, on the yesterday, data fixed before the trial court. They paid for adjournment application and date fixed on 25th September.
That I have mentioned that yesterday I came to knowledge. I have covered by the judgment of justice.
Well, I am serving the copy here now. I read the copy.
You serve in your own way.
Rule 3, there is a court's also duty to serve notice of the application on the caveator. On 48A, subsection 3, where after a caveat has been lodged, the court shall serve a notice of the application on the caveator. That is not.
Yes, sir. Thank you. Yes.
I'm good.
Yes. Call the next matter.
I appear for the petitioner.
Yes.
You will recall that due to certain misunderstanding, the brief was not handed over.
What was the misunderstanding?
But I entrusted with the clerk, but the clerk did not hand it over. But I found that later on that it was not handed over. I inquired that they did not receive the brief. Even on the last occasion, I also, because I was suffering from fever, my lord, I came and immediately contacted.
Why you were not appearing for these long days?
But I was suffering from fever. My lord, I went to my village, and immediately when I came to know.
Why you did not pick up the call? I asked one of the learned advocates to call you. Even then, you did not pick up the phone.
I was in the village.
Learned advocate, I think, called you 4 to 5 times.
I accepted.
Now, what is your submission, sir?
And I leave it before your lordship. But I leave it.
Don't leave it to the court. Make submissions. I will then consider and pass orders.
I have no other alternative. And I have taken instruction
Sir,
from
please, you are a junior member of the bar. Please do not indulge in this type of practice in future.
I apologize.
You are a junior member of the bar. You have a long way to go.
I apologize.
আসুন। Yes, call the next matter.
My lord, I am for the petitioner, my lord. And this is application for extension of interim order, my lord.
Yes.
My lord, can one has been filed within time, my lord? Within time?
Have you served this can
My
one?
lord, can is not served. My lord, every service, my lord, CO has been served, my lord.
Who is appearing?
My lord, that time no one is appeared, my lord. At the first time when it appeared before the Justice Basu, my lord, that is.
When did it expire?
My lord, expired in the month of August, my lord. Within August, proper time has been filed, my lord. Within time, my lord, filed, my lord. My lord, kindly adjourn, my lord. I will.
Expired in August.
My lord, expired in August, my lord. Can has been filed, my lord. Can has been filed, my lord. 29th of August, my lord. If you lordship direct me, I will file, my lord. Well, I can adjourn for this week. I will serve, then after come, my lord. As your lordship.
Seven.
May it please your lordship.
Yes.
My lord, can one is my application for extension of interim order. Now, my lord, both the CO application and civil division application was also served upon the petition opposite parties, my lord, and can one also was served upon the opposite parties.
Can one you have served?
Yes, my lord.
No one is appearing.
And both the applications have been served, my lord. If the affidavit service may be kept with the records.
Still honored, can one of 2025, this canter disposed of. Yes, next.
Sleeping.
Yes, 8.
I'm appearing for the petition against the contempt application that was against the Pradhan of Bharatgarh Gram Panchayat. On the last occasion, Lordship directed them to comply with the direction.
Complied.
Lordship, it has not been complied, Lordship. I'll request your Lordship to come to page 29. Your Lordship, Lordship had directed the petitioner to also be given an opportunity of hearing. That was not given.
Page number 12 of my affidavit of compliance.
Page?
Page 12 of my affidavit of compliance, Your Lordship.
Have you given them a right of hearing?
Lordship, we have served this notice for inquiry, Your Lordship. After that, we have not been able to contact her, Your Lordship.
Lordship, they were in the same village. This is a purely.
Your Lordship comes to page 19, Your Lordship.
They have not served any notice, Your Lordship. We stay in the very same village. It can't be that they couldn't serve us a notice, but to all the private respondents.
Where have you stated that you have you could not contact him? Show me from the affidavit of compliance you have stated that you could not be contacted.
Lordship comes to paragraph number 5, Your Lordship.
Yes.
Page 3.
Where is the order?
Lordship comes to page 19, Your Lordship. Over there, we have found respondent number 19, Bhola Boitdo.
No. Where is your decision?
Lordship, decision starts from, this is the minutes of the meeting, Your Lordship, resolution. Starts from page 16, Your Lordship. Over there, we have inspected.
Have you communicated this order to him?
No, Your Lordship, and we were not given any opportunity of hearing. These are mere submission, Your Lordship. Lordship, they must show that they had tried to reach out to us. They have not shown that. It's a mere submission that is.
How did you issue the notice? By what mode?
Lordship, the Pradhan says Korini.
Sir, is this the manner in which a contempt is being defended? You are holding conference in court. And you have drafted an affidavit of compliance.
Lordship, in this regard, Your Lordship, I will take you to Lordship, page number 19.
Forget about 19. I have asked you one question. What was the mode of issuance of notice? You could not answer that. And the alleged contemptor also does not know that.
Nine.
May it use your lordship. Three matters are before your lordship. Before going into the specifics of the each and every case, what last occasion transpired before your lordship is that here, in terms of the Act, Public Premises Act, and also in terms of the judgment.
Where is the Honorable Advocate General?
Advocate General is coming.
Kindly see the other names.
May I start?
Other names.
Okay.
I've seen the first name.
না তারপরে সম্রাট ইয়ে আছে জিষ্ণুদা আছে থাক না কি হয়েছে
Well, on last occasion, what transpired to your lordship. Under the Public Premises Act, there is a time schedule for completion of FPP.
Mr. Nag, there is time schedule in most of the statutes. Most of the statutes.
Now, all are violated. All. Now, lordship.
কদিন বলবি বল একটা নিয়ে
না আমি 2 মিনিট লাগবে আমার
মামলা বলে যাচ্ছে
now on
Don't hear anything what comes to your right ears.
I'm grateful. On last occasion, lordship has already considered that and also passed a judgment. Now, what we want is these three applications. That one is in respect of Howrah, one is Alipur, and one is Sisi. In these three courts, three
Microphone.
Three learned courts, a huge matters are blocked, and public, the port trust authority are facing difficulties in respect of that.
How many decisions you will cite?
Lordship,
big bag has come.
only paper no decision
No decision. Now, the port authorities are facing immense problem in respect of that. Not only that.
What is the stage of this?
Stage, I will tell you, lordships, by specific. Now, on last occasion, I placed Bandi and lordship's judgment, and also a direction passed by Justice Doctor.
So let us proceed case by case. What is the stage of this? So you want the expeditious disposal
of these three, but along with that, we want a practice direction on the register.
That will come later. Let us proceed.
Lordship, the first case,
because we do not have, I think, 4 or 5 days more before just prior to the vacation.
Lordship. Now,
one by one.
The first case
stage of this.
First case is 1167.
Order 22 Rule 4
is disposed of.
Disposed
no application pending.
So now
ready for hearing.
What is the next date?
Next date fixed 17/7/2025.
For
final arguments.
No.
For arguments.
No.
For arguments. Order. Show me the order.
There is the order.
Mr. Mukherjee, there cannot be a dispute on this. He is saying argument, you are saying no. Order sheets, both of you are reading in a different manner.
I can't go beyond the order sheet. Parties file Hajira through advocate today is for hearing of the appeal on the ground of maintainability. Now, after this long period, they took a plea that appeal is not maintainable. Now, court he is saying no application is pending. Now, court
hearing on the maintainability.
No problem.
So I'm directing to decide.
Right.
Lordship.
Now the appeal, including the.
They are pressing maintainability point. That is the main point. If anyone,
No, this is the first one.
Mr. Nag, what do you want? You want the maintainability issue to be decided fast. Thereafter, the appeal.
Maintainability.
Please.
Maintainability.
There may be two things. You may say, I will not disclose all my points. I will only argue on the point of maintainability. I will provide for.
No. I will pass an order for final hearing if the point of maintainability. Yes, including the point of maintainability. Now,
final hearing including point of maintainability. Yes, absolutely.
Now,
in
addition to that, the last lordship asked me to bring this judgment again. Kindly have a look. In respect of status quo order, this code, the status quo has to be specific. This is the.
But that order has not been challenged.
If you lordship comes to the last portion of the order, lordship will find there is a direction. Register Judicial Service is directed to circulate this order for future guidance and for judicial presiding officer over civil. That portion we want, and that is the first prayer of our civil division also. And I am led by Mr. Shah.
But in 2000,
Please, kindly see to whom it was communicated, for what purpose.
Lordship.
Now you want to whom it is to be communicated. Please think of those two things. I will not say anything.
My lord, I tell you, Lordship, my lord, some precedence has to be given because this is a public authority. There is a judgment of Supreme Court. My lord, Lordship has passed an order.
Consider that I will. Yes, Mr. Shah.
My lord,
You can take over.
my lord, your lordship is right. My lord, so far as the matters are concerned, matter specific, my lord, directions will have to be given. But my
But
lord,
Mr. Shah, only one thing, because yes, statute, there is the provision.
yes,
It is there.
yes.
You are aware in many of the statutes, there are timelines which have been
That's
given.
right.
And it's very difficult, if not impossible, to adhere to those timelines in the other statutes as well.
Yes, absolutely.
So, but because there are things, these from where this time should start. Because nobody, in this case, there was a death, unfortunate death, Order 22, Rule 4 application. So all these things, and as Mr. Mukherjee has said, you have raised a point of maintainability. So there are ways. At times, it is being said, only decide the point of maintainability first. We will not argue on the merits, first decide. So situations differ from time.
Of course, of
So
course.
let us proceed one by one. So in this, according to Mr. Mukherjee or Mr. Nag also said that substitution has been disposed of.
Yes.
So the matter is otherwise ready. What Mr. Mukherjee says that the next date has been fixed for hearing on the point of maintainability.
suppose today my maintainability point goes in my favor or their favor, I can challenge, my lord.
My only thing is,
Let
my
them
lord,
fix, my lord, what point, my lord, whether they will argue on the application or, my lord, because
maintainability, my lord.
application is pending. Secondly, my lord, we know from your lordship's court, my lord, that the entire order sheet has to be looked into. If your lordship see the entire order sheet, the conduct I will show how.
Lordship's court,
My-
entire order sheet has to be looked into.
What we learned from your lordship's court, that, my lord, the person who is coming before your lordship's court for expeditious disposal, the conduct has to be looked into. If your lordship see the conduct of the order sheet, from the order sheet, the lordship will find that the most of the days they prayed for adjournment
my lord,
on the ground of senior advocate.
Mr. Mukherjee, I will remember this in
No,
all
সব
expeditious
ব্যাপারগুলো তো
matters.
মহা মুশকিল। তা বলছো
All
সব remember।
expeditious matters.
No, no,
Very nice on your part to mention, to make these submissions. I will remember this in all expeditious.
Mr.
hearing
Dutta has
matters.
come.
I will look to the conduct. In most of the cases where
Right.
the plaintiff or the party who comes,
আমি এখন বলতে শুরু করি
they take adjournment.
সেটা annex ই করবো না আমি।
বলছি যে
Mr.
matter
Dutta.
specific শুনুন।
Yes, learned advocate general.
Yes, ma'am, kindly.
No, my lord, here, my lord, I am not the advocate general, but my lord, it's very, what should I say, magnanimous on
এটার জন্য।
the part of Mr. Shah to, my lord, permit me
No,
to
no, my lord.
address the court, my lord.
My lord, in his present position, my lord, he has to, my lord, ultimately be accorded that respect.
Yes. So,
Yes.
so Mr. Dotto, in this matter, so the substitution application has been disposed of. And the next date, as Mr. Nag has said, it's on 17th of July 2025 for arguments. Mr. Mukherjee has pointed out that maintainability point will also have to be decided.
Everything may be decided together, your lordship.
Everything. You don't want piecemeal. Please make up your mind.
Yes, yes, yes. My lord, maintainability, jurisdiction, whatever they have, let all be disposed of.
I'm
Keep-
recording your submission.
Yes, yes, my lord, keeping in view, my lord, the statutory scheme. But this is after all, my lord, a summary proceeding.
Yes, yes. देखिए আছে public premises.
Yes.
আছে, তিনি তো।
এই public premises
premises
একটা-
erection of arms.
হ্যাঁ।
Yes.
এটা যশোর এলাকায় রেখে দিন আপনারা।
ওটা রেখে দেবেন তো।
হ্যাঁ, এটা কিশোরদার বই।
It can be retained without
Yes, yes.
permission.
Yes. No, no, it's not government property, it is his personal property.
Yes.
Now, my lord, please have a look to, my lord, the provision of appeal.
একটা রয়েছে আরেকটা দিয়ে দে। কারণ এটা এই তোমার
কোনটা? এই দুটোই আমার।
এটা দেবে?
But kindly have a look to it, section 9, subsection 4. Every appeal under this section shall be disposed of by the appellate officer as expeditiously as possible, and every endeavor shall be made to dispose of the appeal finally within 1 month from the date of filing of the appeal, after providing the parties an opportunity of being heard. Then cost, etc.
Yes, where is the Supreme Court judge?
Yes, but this Bandi's judgment, hey, judgment. But I believe that I'm on the last occasion where it has been handed up to the court, but still, Milord, kindly have a look to Milord. No, no.
Paragraph
with 33.16. Kindly have a look, Milord. But this is reported in 2013, volume 12, Supreme Court cases, page 631.
These are suggestions.
Yes. May I please take
suggestions.
Yes, yes. Kindly take my your lordship is that para 33, Milord?
Yes, yes, I've seen that.
Yes.
So 33.16 also forms part of the suggestions.
There are two things, Milord. First is, Milord, under section 9(4),
there is a timeline.
yes. In order to eliminate unnecessary delay in disposal of such cases. Now, Milord, 1 month, Milord, cannot be extended to 1 decade.
So the last day the substitution application has been filed. So what can be done?
But substitution was required because of the delay only. The substitution wouldn't have Milord, been a necessity had it been Milord disposed of. And Milord,
not in all cases. Maybe
definitely in 1 or 2 cases. Therefore, Milord, what I respectfully submit is, Milord,
from this 1 month,
yes,
though the statute says from the filing,
yes,
but in practical purpose, from which day this 1 month shall start?
it should start, Milord, Milord, going by the statute. I have to interpret it, Milord, by the statute,
because
with subsection 4 says from the date of filing.
Yes. It says from the date of filing, thereafter these stay applications and other things are there. So when you file an appeal, notice has to be served. It takes time. Thereafter, stay applications will be filed. Other side will come and say, I have to give opposition.
Yes, it's definitely. These are
1 month cannot be, it's not possible to adhere to this. So, has to be interpreted from which time this 1 month is to start, though the statute says.
Milord, your lordship, Milord, under Article 227 is exercising supervisory jurisdiction. Now, Milord, I can well appreciate that the court has to be practical. But, Milord, at the same time, Milord, the court should also take note of, Milord, the inordinate delay in the disposal of these appeals, which ultimately, Milord, renders the provisions almost ocious. Milord, we need to, Milord, also look into the statutory scheme. Now, Milord, in
why this summary? What was the necessity for this summary proceeding?
Yes,
that is your submission.
Yes, because these are all public properties. Therefore, in public properties, Milord, which are meant for the public, Milord, this summary procedure, Milord, has been provided under this statute, or a special statute has been created for summary disposal of this application, of these appeals, applications, whatever it is, because the reason being that these properties are meant for the use by the public. Therefore, I also, as a member of the public, if I want a particular public property, I can also put a claim over there. And I may or may not succeed in getting that property when I compete with others. Therefore, Milord, the statutory scheme has to be kept in mind. Today, Milord, in this particular case, Milord, there is a substitution application. Milord, your lordship may consider the next date as the starting point. Consider it as the next date as the starting point. And Milord, send, Milord, some, what should I say, administrative directions also, Milord, to the different courts below, so that, Milord, 2 things are achieved.
Yes,
two things are achieved. One is early disposal, and second is, what is very important is, Milord, a person is getting a stay at peanuts. Why I say, Milord, my claim is, say, 6 crore is the due. and the direction is as a condition for stay, pay 10,000 rupees per month. Therefore, these two aspects have to be looked into. Now, my lord,
For that you can challenge.
definitely, no doubt about that.
You are aggrieved by the fixation of the
Yes.
quantum of the occupation.
Absolutely, absolutely. But my lord, some message should go, my lord, from the highest court of the state also.
But
So,
moreover,
and
this
you know,
revision is also
the-
defective. This revision is also defective because my dead person has been made party.
No, take all the points over there. But
In this revision, my lord, this
my lord,
revision.
I am not standing in the way of, my lord, the appellant to take what they have.
Who is
My lord, kindly see, my lord, opposite part number 3, Estate Nurubhai Jivanji, represented by Manwar Nuruddin. This Manwar Nuruddin is proposed. Substitution not allowed. Proposed. এটা ছিল না না kindly see the then my lord, kindly see propose this particular 2% died. Tariq Taher long back died. However, my lord, in the court below now, my lord, substitution has been disposed of. But my lord, kindly see the when the division 3 persons was বলে দেওয়া উচিত না আমাদের ডিউটি এটা না নিশ্চয়ই
Whatever the cost title was available, we have made over here. But one more thing with Justice Dotto's direction will
I have seen that,
Yes.
Mr. Dotto,
Please
but-
consider, my lord,
but
passing
only
rules.
one thing. To whom that was directed to be circulated?
This is kindly direct circulation in the same manner.
To whom?
With the yes, directed to circulate this order for future guidance of the judicial officers presiding over the civil courts.
No, it's for the police. It has been. No, this was for the status quo.
Yes, that status quo order, my lord, that status quo should not be granted as a matter of
they have
course.
to challenge. There is a judgment of Justice Sinha also. They ought to have challenged. 2012 order was passed.
Which order?
But 2012 injunction was passed in their presence. That injunction was continuing. In 2023, my lord, they are coming before your lordship's court.
This application under Article 227 of
My lord, for the petition. Last occasion, my lord was pleased to direct me to obtain information seek regarding the record.
Yes, what does the information say?
Record traced out, my lord.
Out.
Yes. Order dated 39. My lord, it is a partition suit of.
So it has been fixed now on 10th of July 2025.
10th of July. My lord, suit of 2011. My lord.
Records were not.
Yes.
fixed out. Now it has.
No, my lord, that is last occasion.
Earlier matter also. Records
Last
were fixed.
occasion, my lord, only when it was transferred from first court to third court, it could not be.
Now, after all, it has.
Yes,
been
yes,
fixed out.
yes.
So I'm directing the.
Yes, yes. My lord.
Appearance.
Or 1 year, my lord, because 2011, my lord.
Proceeds. Yes, next. Call the next matter.
14. He is done.
Yes, that matter.
Yes,
Where is
that
the
matter.
revision application?
Lord, that revisional application is
35. Item number
33 and 35
That is appearing in the list today.
appearing in the list.
Yes, so then Mr. Chatterjee, his
Yes,
application is to be taken up.
Absolutely.
Because,
My lord,
item numbers
33 and 35.
33 and 35. বাদ করেছেন কোনটার সঙ্গে কোনটা রিলেটেড এটার সঙ্গে এটা Yes, this is 33.
33.
Yes, Mr. Manager.
Eta. Lord, 33 is CO number 1655 of 2025. Lord, your lordship, Lord, the 2 points, Lord, I shall argue. Lord, if your lordship kindly come to that page 51. First of all, degree, my lord. Page 44. First of all, decree. Decree, which is sought to be executed. Lord, page 40 and 41. Kindly come to page
41.
41. Lord, judgment data claim for declaration that he is a Tika tenant.
The manager is not going to that because, after all, please concentrate on the impugned order. If I have to go to the merits, it's very different. Then I have to admit it, I have to put it under the heading here.
No. On point of law.
Because
only point, my lord, is no. Only point is, my lord, before very well, my lord. Only point is before your lordship whether opportunity was given to them. No. Then yes.
Now only by the order impugned, stay was granted subject to certain conditions.
stay was granted in respect of 17 bighas
Yes, yes.
entire.
Stay
Lord,
was-
he is claiming 12 and 10
I'll
kathas.
finish that. Stay was granted subject to certain conditions. Mr. Chatterjee was aggrieved by imposition of such conditions. He has approached. You have also challenged. You are saying that the stay in the manner what has been directed by the impugned order ought not to have been passed. So that is the scope of the impugned order. Please, you are making
Right. And second, my lord, whether their contention is no opportunity was given to them to file objection against the supplementary affidavit. These are the two questions, my lord. Lordship, kindly come
And
to
what
the.
is your challenge with regard to that order?
Yes, Lord, my first challenge is that the court ought to have stayed on condition in respect of 12 and 10 kathas, not 17 bighas.
12 and 10 kathas means I could not.
Because two cases, one
Let
is,
us concentrate on one, otherwise I will.
yes, 12 kathas.
This is 12 kathas.
Yes. But my lord, decree, if your lordship kindly come to the degree, come to Lord, very short point, page 49.
Let me first see CO 1655 and 1441 are interrelated.
Yes, 1655
And 1441. Mr. Chatterjee, please take up.
58. 33 and
1655, Mr. Chatterjee, your matter is 1441. These are interlinked.
1441.
These are interlinked.
interlinked.
Your matter is of 24.
25.
Order ভুল আছে। Order sheet এ ভুল আছে। Order record করুন। PO 1441 এ
Page 49. Lord, decree, Lord, in respect of 17 bighas, 7 kathas.
49.
Yes. Decree in respect of 17 bighas, 7 kathas.
17 bighas, 7 kathas.
7
This is
kathas.
the entire. This is the
Entire degree. Now, Lord, the entire decree has been stated. What they are claiming, Lordship, kindly come to Lord, page 51. Page 51.
Yes. 51.
Lord, they are claiming
This is case 14 of 2023.
by 14 of 23. Page 52, my lord. Paragraph 2 and 3 and 4. Paragraph 2, 3 and 4. They are claiming 12 kathas, 13 chotas. Paragraph 2 and 3.
Paragraph 2 is sufficient.
Sufficient.
12 kathas, 13 chitaks.
Yes. As per agreement. Lord, with the judgment data.
That is their claim.
Lordship. And what they have prayed for, page 56. To adjudicate the question raising to the right, interest and possession of the petitioner in respect of the above property. Lord,
About
what?
12 kathas.
Yes, 12 kathas.
Yes.
Lord, as a matter of right, I am telling your lordship, that your lordship sees, therefore 12 katas they are claiming.
So
Now-
according to you, this stay ought to have been restricted to these 12 katas, 13 chetas, so far as this matter is concerned.
And secondly, my lord, if they say, and what is their objection, your lordship kindly come to the, because we raised a maintainability point, because we do not want to go into that question now. Very short question.
Yes.
Lord, your lordship kindly come
Show me
to,
how that was dealt with by the executing court.
yes, come to page 63,
63.
relevant at 64, my lord. Page 64.
Yes. No, the impugned order, how it has been dealt with in the impugned order.
Yes, impugned order.
According to you, this stay should have been restricted to these 12 katas.
Right.
How that has been.
That has been dealt with.
Yes.
Right, my lord.
Show me that.
Lord, order dated 10/4/2025.
10/4/2020.
2025.
That is the order with Mr. Chatterjee is also challenging.
Yes.
Yes. Now, Lord,
10th of April.
according
Yes,
to the,
show me that portion where it deals with this.
now, Lord, calculation of area with regard to the, that is according to the trial judge,
Yes.
Lord, 90 square feet according to the report of the engineer.
Yes.
90.
Yes.
But he has relied upon a judgment of this honorable court and fixed 65 per
Who has
square.
relied upon? Who has relied upon? Mr. Chatterjee has relied upon.
No, we have relied upon.
Oh, you have relied upon.
In
Yes.
the supplementary affidavit, objection, supplementary objection.
So, according to the valuation report, it's 90 per square feet.
Yes. The court has awarded 65.
And
Lordship
Court
kindly come
allowed-
to
it's 65
65.
per square feet.
Yes, it is pointed out before this court occupation.
For 12 katas, there is no dispute with regard to that.
There is no dispute with regard to.
Show me that calculation where it has been made.
Then
that-
calculation, my lord, 7,200 square feet. Plus 4 into 45, 180 square feet and 48 square feet, total 7,420 square feet.
No. This is 12 katas. 12 katas is 9,225 square feet.
Page 2, last paragraph.
Oh, this deals with both. The other is 10 katas.
13.
The impugned order is a common order.
No, not common order, separate order.
Next 2-3 lines
Yes.
thereafter it says 10 katas, 4 chetas. All right, let us proceed on this. This 12 katas, 13 chetas is 9,225 square feet.
This is a common order, yes. That is 10 katas, 4 chotas, 48 square feet.
Yes.
And another is,
So 65 square feet the court holds
yes.
at rupees 65.
And then, my lord, now as far as calculation of area occupation charges in connection with the present appellant is concerned with reference to Annex D to the supplementary additional written objection, it is submitted that an amount of rupees that is due since August 2003, but nothing has been shown as to how
August
present
2003.
market rate of valuation report.
August 2003 is the date of the decree.
Date of the degree.
August 2003.
3.
What is the exact date?
And that is I am telling your lordship. Exact date, page 447. Page 40.
Yes, Mr. Banerjee, where is that discussion with regard to the entirety or piecemeal? Where is that discussion of the Planet Executing Court?
Yes.
Where
That
is that discussion according to you?
No discussion.
Show me the
Yes,
you have
that
raised
is I am
this
telling
point.
you, lordship.
Show me that you have raised this
Now,
point.
as far as calculation of the area occupation charges in connection with the present appellant is concerned with reference to Annex D to the supplementary additional written objection, it is submitted an amount of rupees so and so since August 2003, but nothing has been shown as to how the present market rate of the valuation report can be considered for a period since August 2023. Then in such situation, in view of the order of the Honorable High Court wherein the Honorable High Court has been pleased to direct the court to dispose of the application for a stay as expeditiously as possible, but preferably by the end of April 2005, without granting any unnecessary adjournment to either of the parties, it appeared that the instant application for a stay is to be disposed of, allowing the prayer to stay all further proceeding in title pending before this one so court till the disposal of the present appeal.
The entire execution case has been stayed.
Entire execution case. Now, Lord, your Lordship kindly come to that there was a supplementary affidavit. Then second point, my Lord, that his finding is, he is based on the finding that according to the report, 90 rupees. According to the court, because he relied upon a judgment of this Honorable Court in CO 2663 of 2024.
Where is that?
Lord, in the impugned order,
No. Where is
second
that
third
decision?
paragraph.
Give me that decision.
Yes, I am giving that decision.
Who has referred to this?
Lord, certainly we have referred.
You have referred?
Lord, it has not been mentioned whether we have referred or they have referred. It has not been
Both of
mentioned.
you must be knowing who has referred.
At this juncture,
All right, so it does not matter who has referred. Please
maybe
give me that decision.
maybe, my Lord, that the judge knew about.
All right, please give me
That is why, yes.
Going by the appearance plot, it has to be Mr. Banerjee.
You can also take out this website. You can also take out Mr. Chatterjee.
Everybody
It's
can
not
take.
that Mr. Banerjee appeared, he has cited.
Yes.
Would have been in the earlier days. Those certified copies.
Yes,
everything. So
now, Lord, everything is on.
available.
Everything is available on.
From that, you cannot say that he has cited. Yes. Yes, Mr. Banerjee. Anything more?
Yes, Lord, here also the court has said that relying upon that judgment, he fixed, my Lord, 65.
Yes.
That is 90, therefore he had fixed it because it is a commercial. It is a commercial. And now, my Lord, your Lordship, then, my Lord, he recorded a finding that there was no objection filed against the report of the, there was a finding.
Where is that?
Yes,
Where
yes,
is that?
that finding, my Lord, I may. As far as the area occupied by the appellant is concerned, it appears same is to be considered as it has been mentioned in the report. Lord, page 3, my Lord.
Yes.
After first paragraph, then
Show me
second
that
part.
line wherein it has been stated that they have not filed any objection. To
Yes,
the
yes.
report.
Yes, Lord, kindly come to, it has been pointed out. Lord, third paragraph. Middle page 3.
Page
Page
3,
3, my Lord. Page 3, my Lord, third paragraph. As far as the area occupied by the appellant, it's keep over, my Lord, 3-4 lines thereafter.
Pointed out.
It has been pointed out before this court that as per report of the special officer appointed by the Honorable High Court, Annexure B, to the supplementary additional written objection filed on behalf of the respondent, measurement of the plot number so and so. So, on hearing both the sides and in view of the above valuation report wherein has been fixed on the basis of 12 kata 13 chota square feet or 9,225 square feet at the rate of 90 per square feet per month. As it is pointed out, it appears in view of the report of the special officer appointed by the Honorable High Court regarding the area occupied in ferrometal showing 10 katas, so and so. Lord, this is the next matter. The 10 katas, so and so. The said area, it is pointed out before this court, the occupation charges as per foregoing discussion 65 per month can be fixed, rupees so and so per month, as far as the present appellant is concerned. Now, as per calculation of the area in connection, now, my lord, here, your lordship kindly look to the second page, lord, finding with regard to that part. Yes, my lord, page 2, my lord, towards the bottom.
Page?
Page 2, my lord.
Yes.
In such situation, considering all aspects, it appeared the order of a stay of all further proceeding, my lord, third paragraph.
Yes.
Of the execution may be passed with occupation charges to compensate the decree holder in view of the order of the Honorable High Court. Now, as per quantum of occupation charges is concerned, it appears to be reference to supplementary additional objection supported by an affidavit. It has been claimed on behalf of the respondent number 1, Lord, that is my client, that the appellant petitioner should pay as occupation charges in this connection papers regarding valuation report annexure C prepared by the person with B civil qualification for assessment of the fair rent as on the date per unit area per month with the help of the e-assessment slip obtained from the Directorate of Registration and Stamp Revenue Government of West Bengal in view of the present market value as it is submitted is highlighted on behalf of the respondent. It is submitted on behalf of the respondent number 1 that this amount of occupation charges has been fixed on the basis of that area per month as per papers regarding the valuation report. Though it has been contended on behalf of the appellant, respondent is not entitled to any occupation charges, but nothing has been pointed out on its behalf that it has placed on record anything to challenge the contents on an affidavit on behalf of the respondent number 1. Lord, this line I may draw your lordship kind attention. Now, Lord, now your lordship kindly come to the written objection, supplementary written objection. To Lord, kindly come to that page. Lord, page 78.
This is supplementary written objection.
Supplementary objection.
This is filed by Mr. Chatterjee's client.
No, it was filed by us on 25th. Lord, on 25th of March, Lord, we have submitted it and they acknowledged it on 25th itself. And here we made a prayer, maybe please to reject the application for a stay in respect of the property in question. Page 82, my lord.
Yes.
Now kindly come to, my lord, page that there was a special officer report was also submitted by us about the extent of the occupation of the.
So that was the report pursuant to the order of this court.
Order of this court.
Now, with regard to this, I have directed those report to be circulated to both of you.
Both of them.
So there is none of you are challenging that report.
None of them never challenged the report. Yes, none of them challenged the report.
So there is no challenge to the.
No challenge to this report. Lord, this was marked as an exhibit.
So what did the?
This was marked.
No, what did the report say? Any area?
Yes. Report. 12 kathas.
12 kathas.
Lord, area. Lordship kindly come to
So that
page
is
95.
Exactly what is being stated.
Yes.
here. So there is no dispute.
No dispute.
And
Page 95 and page.
any demarcation.
Yes, page
Yeah,
95.
there was a map.
Page 95. There is a map.
Page
95, my lord.
Yes. Oh, these are the plot numbers 10 and 12.
10 and 12. One case, my lord, with regard to 10, that is, my lord, the next case.
How it is demarcated? How this 10 and 12?
There was a colored delineation.
Oh, Mr. Chatterjee, yeah, I've got those lines. I'm asking you, both of you, how these are demarcated, these plots?
Well, that's on the basis of
He
the
helped the surveyor. No. The special officer, my lord.
no, not marking as such physically, my lord, we are in occupation of this part. There is no dispute on that at all. How it was done, my lord, it was done with the help of an Amin.
Amin.
Who was
surveyor.
I'm asking both of you, any marking, any pillars or anything
boundary
physically?
Boundary আছে? There is a boundary.
Form of that boundary.
পাকা করা না এ করা?
Sometimes it is putting pillars.
I understand.
sometimes-
কি আছে? Tin.
Mr. Banerjee, your instruction is also that. So these plot numbers, now
10
we are
and 12.
concerned with 10 and 12.
10 and 12, marking.
I am only.
These are physically
They are
demarcated.
physically demarcated.
And there is no dispute.
There is no
because
dispute.
the special officer has also said that.
Absolutely.
I would pray your lordship would
Time
not,
is not in dispute.
my lord, your lordship would not have to go into that after my learned senior friend finishes.
Yes, so let me for the present understand.
It is demarcated.
So there is no
Demarcated.
dispute with regard to 95.
95.
And this measurement of at page 92. Measurement at page 92.
There is a boundary wall as well.
And in present, because boundary wall. Lord, page 96. Lord, the
Please. Yes, Mr. Manager.
now, Lord, page 96, your lordship kindly come to page 96.
Yes.
Lord, both the parties were present, the learned advocates were present.
Mr. Banerjee, let us
Yes.
not go into that.
Yes,
Mr. Chatterjee has said, both of you are saying there is no dispute with regard to that.
I need not go into that, my lord.
Yes. So now, Mr. Banerjee, your submission is that since they are in occupation of 12 katas and 10 katas, the entire execution case could
Can't
not
be,
have
my
been
lord.
stayed.
Can't be.
So you should be allowed to proceed to execute the balance portion.
Yes,
That is yours.
yes.
And according to you, 65 should not have been the rate. It has to be 90.
It has to be 90 or something less than that. Maybe 70. That court
than
is doing that,
65.
but we said 90. We
But
said
more
90.
than 65.
Yes,
Anything more, Mr. Banerjee?
yes. Now, my lord, your lordship kindly come to page 102, my lord.
100 and?
102.
Yes. What is that?
Lord,
The report.
that is the report of the
Valuation.
special valuation report. Rent a square feet, my lord, valuation. Now, my lord, your lordship, then third point, my lord. This is the, your lordship kindly see that his report is from 2004 to 2003 onwards, my lord, he said that. Court has said that he did not. The report, he overlooked it.
No, I could not follow. What he overlooked?
Lord, the area that he has been determined,
Yes.
Lord, with regard to this,
Yes.
Lord, that is according to the present market value.
Question.
Present market value. Lord, now another thing. Lord, another thing is, Lord, the court has said that the area shall be calculated thereafter. Kindly look to the impugned order, my lord. That is totally wrong.
Mr. Banerjee, what is the basis of arriving at this occupation charges?
Lord, basis, Lord, it is a basis of the Lord that the basis,
Banerjee,
Lord, has been
There
mentioned
are
in
two
Page
three
102
methods.
and 103.
Mr. Banerjee, there are 3 methods for calculation of this occupation charge.
Yes, my lord, that method, my lord, has been adopted.
Show me that.
Yes.
That all these methods have been adopted. And what are the methods?
Lord, kindly come to page 102, my lord.
Yes. Show me the methods, the name of the methods which were considered, how it was calculated.
I have noted page 102, my lord, the third paragraph.
Mr. Banerjee,
I have
that is
noted
the location. That is the location.
That is the
Calculation
location.
is at page 103.
Calculation page
Please
103.
satisfy me what method was adopted for arriving at this figure. What is the mode of calculation?
Lord, mode of calculation, my lord, he mentioned in his report.
I'm asking you, satisfy me what is the mode? Because he is an expert. He has to mention the methods by which valuation is to be made under these circumstances. Show me reflection of that in the valuer's report.
Lord, method, my lord, how he has stated this, my lord, your lordship kindly come to, Lord, pay from the
Banerjee.
e-assessment slip enclosed from the page 103.
Yes, 103, yes.
From the e-assessment slip enclosed.
Yes.
Obtained.
What is e-assessment? What
The
is
present market
e-assessment?
value
Yes.
of 13 bigha 12 kathas.
Yes.
So
That
and
is the
so
market value.
entire land area of the said holding is so and so.
Mr. Banerjee, this is the market value of what? Where is the e-assessment slip? Whether it's for transfer or it's for lease rent. What is that? And there are methods to calculate this. Mr. Banerjee, a report of an expert, what is material, is the basis on which he has arrived at that opinion.
Lord, on the basis of the...
Because court can look into the way in which that opinion has been given.
Yes. Court has looked into
Can-
that and court accordingly 65.
No, satisfy me that how the valuer arrived at this figure. What are the methods? E-assessment slip. Where is the e-assessment slip? Because the evidence also shall form part of the record of a report of an expert. The evidence collected by him, e-assessment slip. Where is that?
Lord, e-assessment from the e-assessment slip, Lord.
Yes. So e-assessment of what? Where is that?
E-assessment of the market value.
Mr. Banerjee,
Of
market
land.
value may be of different types. One is rental
Yes,
value.
rental
one is-
value and market value.
Yes,
Where is the
where is-
difference?
Nothing has been
Rental
mentioned.
value and market value. My lord,
Yes, where is the market value of
it
what?
said effective market value
Of what?
for considering
Rental
rent of
value.
commercial property, 8%. Lord,
It's
he
rental
proceeded,
value or the transfer value.
Lord, he proceeded on the basis of 8% of the market value. Total market value e-assessment slip and he proceeded on the basis 8%.
What method?
Rental.
So,
Lord,
Mr. Banerjee,
Lord, may I draw your lordship kind attention. So, effective market value is so and so. Therefore, considering the rent of commercial property to be 8% of the market value, rent per square feet per annum. Therefore, he proceeded on the basis that
what is the
e-assessment
basis
slip.
of this? That rental value will be 8% of the market value. What is that method which states that the rental value will be 8% of the market value?
My lord, 65 per square feet. My lord,
Mr.
he has
Banerjee,
given.
it's not that. If you want me to look into this valuation report, you have to satisfy me that which method states that 8% will be the rental value of the market value of the property. He has to state this, that this is the method which states and this is the market value and 8% thereof.
Lord, on the basis of 8% he has gone. On the basis of a market value.
He has not stated
Market
anything with
value
regard
of
to
the
the method.
market value of
He
the
has
rent.
not stated with anything with regard to the method. Which method
No, he
states?
has not stated anything as to the method. He has
Which
not
method
stated
states that
anything.
it will be 8% of
Lord,
that.
I cannot develop, my Lord, before your lordship, Lord, with regard to the method.
Yes, yes, you cannot improve upon what
I
is.
cannot improve on the basis of
Yes.
the, what is there, that is I am submitting before your lordship. He proceeded on the basis, my Lord, that the total market value according to the e-assessment slip is so and so, and accordingly 8%. Now, my Lord, according to the municipal value, my Lord, 12%. Rental value. Municipal value. He proceeded on the basis 8%.
So he has to state that, Mr. Banerjee, municipal valuation
Lord,
is thus. So,
Lord,
but I am
at
not
least,
taking
Lord,
that.
at
I am
least, Lord,
taking
I am
this.
drawing your lordship's kind attention that he is occupying the property
That
of
is,
tenancy
Mr.
order.
Banerjee, that is a different thing altogether. He is occupying, he has to pay. Now, what should be the quantum? If you are to challenge
Quantum,
that
Lord,
quantum,
the court has accepted this
anything
report.
more, Mr. Banerjee?
Court has accepted the report.
Anything more?
Now, Lord, if, Lord, my one submission, yes, Lord, my one submission, Lord, 227 application. Lord, if two views are possible, if one view is taken by the trial judge, Lord, then, my Lord, 227 cannot be invoked. Lord, a person is occupying the property.
When
Lord,
Banerjee, both of you are challenging, so it seems that this order should be set aside. Both of you are.
No, we are challenging with regard to no. We are,
want
Lord,
excess, you want
distinction is,
less.
Lord, distinction is, we have challenged it on the for modification of the order.
Yes, yes.
They have challenged
He
it
is
for
also
setting
paying for
aside
what?
the order. For setting aside.
No, he is also paying for, maybe, Mr. Banerjee, all is for.
His
prayer is for
revision
setting aside.
application prayer is for setting aside.
But I think Mr. Chatterjee will not say that allow me to occupy without payment of any occupation charges. If he makes that submission, then I will consider that.
Lord, then your lordship kindly come to the area also give him.
Yes, area, Mr. Banerjee, area will be from the date of the decree he has to pay.
Yes, now,
So
Lord,
only
date
the-
of the decree, my Lord, may I,
There is no dispute.
may I
with regard
verify,
to
my Lord,
payment.
may I verify, my Lord, date of the decree. Lord, page
That
40.
you can, yes, Mr.
Let
Chatterjee.
me place, my Lord.
Yes, Mr. Chatterjee.
Page
He is
40.
only verifying the area. Yes, yes, to start.
No, another thing, my Lord.
Yes.
His contention is that he was not given opportunity of being heard.
According to you, you have placed
No,
that poster.
kindly come to the order sheet, my Lord.
Yes. You have placed this portion in support of your case, page 2, last 3-4 lines.
Lord, your lordship, there are two applications at page 111, annexure G.
Yes.
Lord, this is an objection against the application for the purpose of releasing the other portion of the property. Lord, that application
Filed by you.
filed by me. Lord, that application is, your lordship kindly come.
What happened to this application?
May I, Lord, practically this has been disposed of impliedly in terms of the
No, Mr.
explanation of
Banerjee, where is
section
the
11.
that release the balance portion? Where is that?
Yes, Lord, kindly come to 107.
107.
Sorry, 108.
There is 108. To release the balance, 15 bigas. 17.
15 bigas 11, page 108.
Yes, 12 and 10. 32.
32. No, 12 and 10, 22.
That is one
Sorry,
biga.
22.
22.
1 biga certain.
22. Now, my Lord, your lordship kindly come to that page 107. Lord, 15 bigas 11 chotak 30 square feet.
Page?
Page below 108.
Yes, yes. So you have prayed for release of this 15
Because the digital property is 17 bigas and odd, out of which some has been acquired.
Oh.
Some has been acquired. And my Lord, the compensation has been paid and it is a commissioner's or police office.
So according to you, the
remaining area is
excluding Mr.
15
Chatterjee's
bigas,
land,
11 chotak 30 square feet.
the portion excluding Mr. Chatterjee's occupation.
Oh, yes.
That you want release.
That I want. Lord, now your lordship, this application was served upon them. Lord, on 25th, we have served. And 26th, my Lord, it come up for hearing.
Was this taken up for hearing?
No. Yes, no. This has been impliedly disposed of.
Implied.
In view of, yes, in view of the civil procedure code. Explanation, 11, section 11. If a specific degree is not passed, then it shall be deemed to have been refused. No, kindly read the order then. Kindly read the order then. Let me read the order, my lord, to satisfy.
Order says whole.
Yes.
All right. So
No,
according to
what I am saying before your lordship,
Yes.
that they have filed an application, they have filed objection against this application.
They have filed.
They have filed objection.
That is their objection.
The objection is page 111, Annexure G.
When they have filed objection.
They have filed objection on 1/4/2025.
1/4.
Four.
So prior to the hearing.
Prior to the hearing. Now, they did not use any objection, file any objection against that supplementary objection. Because they say court has directed them to file objection on all the petitions.
All right.
They did not.
So according to
That
the
when they,
impliedly rejected by the
my submission is, my lord, when two petitions were served on them on 25, Lord, on 1/4, Lord, they file objection, then why they did not file objection with regard to my supplementary objection? What did not prevent them? Now kindly look to the order. Kindly look to the orders, my lord.
Which order?
The order sheet with regard to the opportunity given to them or not.
Where is the order sheet?
That is, I have given the entire order sheet before your lordship in the revisional application.
Oh, you have annexed all the.
I have annexed the certified
Yes.
copy.
Which order you want me to see?
Kindly come to order number 9, my lord.
Order number 9.
9. It is submitted that in view of the order, that is 21/3/2025, the application for a stay to be heard for hearing the same, for hearing the pending petition, but both parties do not move together, heard separately. In the present situation, 26/3/2025, for hearing the application for a stay with direction to both sides to get ready positively in view of the order of the Honorable High Court and also for hearing the pending petition. Now, Lord, your lordship, then kindly come to page order number 10, dated 26/3/2025. Parties take a step, supplementary objection against the application for a stay, along with an application for releasing the order of a stay in respect of portion, as it is mentioned therein, is filed on behalf of the respondent number 1, serving copy along with copy of order of the Honorable High Court and other enclosures it is submitted. At both sides pay for taking next date for hearing of the stay application and pending application, order 6 rule 17, after providing opportunities of both the sides to file written objections if any. Opportunities is given, both sides. Then at this stage, an application is filed on behalf of the appellant, moved by the learned advocate of the appellant, praying for extension of interim order of a stay. Learned advocate of the respondent submits as per order of the Honorable High Court, the court may impose condition to extend the order of a stay. On hearing both sides, the interim order is extended till next date with observation that hearing of a stay application is to be conducted on that day in view of the order of the Honorable High Court. 1/4/2025 in view of the order of the Honorable High Court for hearing the application for a stay pending application and application for releasing the order of a stay in respect of portion as it is mentioned therein with opportunity to the appellant to file written objections. Lordship, kindly see. Now, Lord, we serve the copy on 25th. The releasing petition as well as the supplementary objection we submitted on the same day. Now here therein with opportunity to the appellant to file written objections if any against the applications of the respondent. Lord, then you are given opportunity. Lord, they wanted to delay. Lord, appeal was preferred. Lord, we file an application. Lord, for the purpose of maintainability of the application under order 21 rule 97. Ground is one case, next case is subtenant. The party who file an application, subtenant, judgment debtor, subtenant, subtenant. Another melody is judgment debtors, subtenant. Lord, this is the case. In both the cases, therefore, Lord Court, relying upon the judgment of the Supreme Court, Lord rejected a straightway because no evidence is required. Lord, Lordship knows that judgment. Lord, I have brought that judgment before your Lordship. Silver line case. Silver line cutout. 8:30.
Yes. Yes, Mr. Banerjee.
1998 AIR ACW page 1544.
Yes.
এই আর একটা দেখো না কপি আছে এআইআর এ তো আছে দেখছি বলে দিচ্ছি দাঁড়াও এসিসি তো আছে তো বলে দিচ্ছি 1998 volume 1 Calcutta High Court notes page 141 Supreme Court.
SCC is 1998 volume 3 SCC 7.
Yes. Lordship, kindly come to.
Yes. Paragraph.
Blood paragraph. Lord, kindly come to page 6, my Lord, towards the bottom. We are in respectful agreement with the above statement of the law. What a statement of the law? Lord, a statement of the law is that Order 21, Rule 97, Sub-Rule 1, read with Order 21.
No, Mr. Banerjee, I have not got that.
Yes.
Which page?
Page 5-6, my Lord, towards the bottom. We therefore agree with the contention of Mr. So-and-so, the learned senior counsel for the second respondent,
yes,
that High Court went wrong in holding contention of the second respondent cannot be considered under Order 21, Rule 97, but the aforesaid finding is not sufficient to dispose of this appeal. Mr. Sibal contended that second respondent, being a subtenant under the first subtenant, he is bound by the decree of ejectment, albeit he is not being made a party to the suit in which decree was passed. Quite clear that the second respondent is a tenant under the first subtenant. This can be gathered from paragraph 6 of the application filed in the executing court. Now, Lord, the court held that either you may be a Lord protected subtenant, otherwise you have no right because you are claiming true judgment debtor, and accordingly no evidence is required. Lord Court has straightway rejected the application. It is a statutory, my Lord, page 6, a statutory mandate that the decree of ejectment shall be binding on every subtenant unless he falls within the ambit of subsection 2 or subsection 4 of section 13. There is no case for the second respondent. He has given a notice to the landlord before expiry of the time schedule in section 16, nor has he a case. He would fall within the purview of the aforesaid two subsections in section 13. Of course, learned counsel for second respondent contended that the instrument of lease as between so and so permitting a tenant to create a subtenancy. Learned counsel argued this and this. Now, Lord, section 16(1) was quoted. Then ultimately, the court, my Lord, in this view, thus, without any difficulty, it can be held consent given by the landlord to his tenant for eviction or creation of a subtenant is valid only as between landlord and his tenant. Such consent cannot be used by a subtenant to create another subtenancy under him so as to bind the landlord. For the aforesaid reason, we allow the appeal, set aside the order under challenge. We hold plaintiff is entitled to delivery of possession by removing obstruction resistance made by the second respondent. Now, Lord, here Summarily, it was rejected on the basis of the application made by you. Lord, what is his right? If your lordship looks into two paragraphs, therefore, lordship knows the judgment of Honorable Justice Horitondon that under Order 41, Rule 5, in all cases, stay cannot be granted. If it is a case, if it is clearly a case which is not maintainable in law, then court is not readily accept that condition. Court may not, court straightway will reject that application.
Take it out here, Mr. Chatterjee. Yes, Mr.
Yes.
Chatterjee. Yes, Mr. Chatterjee.
Now, my lord, your lordship, another order. Lord, your lordship, kindly come to another order. Only 2 lines. I do not want to trouble your lordship. Lord, order dated 1/4/2025. But it is mentioned there in Lord after fixed 2/4/2025 in view of the order of the Honorable High Court for hearing the application for a stay, pending application and the application for releasing of the order of a stay in respect of the portion that it is mentioned therein, with the opportunity to the appellant to file written objection against the applications of the respondent. Lord, here I am again meeting that point. Applications of the respondent and to the respondent to file objection.
That your application for releasing was impliedly rejected by the impugned order.
Yes, now your lordship kindly come to the impugned order. Impugned order, what is the impugned order?
Entire
Operative
execution
part,
state.
entire execution state, not only that, my lord, that the, as far as, kindly come to the last, lord, page. In such situation, in view of the Honorable High Court, wherein Honorable High Court has been pleased to direct this court to dispose of the application for stay as possible without granting any, it appeared that the instant application for stay disposed of, allowing the prayer to a stay of all further proceedings pending before the civil judge till the disposal of the present appeal, with a direction to pay occupation charges in favor of the decree holder respondent number 1 before the trial court, and the civil judge with a direction to both the parties to place proper documents for ascertaining the area amount. Now, my lord, your lordship, kindly look to the section 11 of the Code of Civil Procedure explanation. Lord, I may invite to a lordship kind attention the explanation. Lord, explanation 8 possibly, that if, Lord, explanation of section 11. Lord, there it has been said, if the specifically it has not been granted, then it shall be deemed to have been refused. Lord, that principle will apply. Possibly for 4 or 5 or 6. Explanation.
5.
5.
Relief claimed in the plaint which is not expressly granted by the decree shall for the purpose of this section be deemed to have been refused.
Therefore, that application has been rejected, entire has been given. Other matter, same, my lord. Other matter, same. Lord,
Other matter is only 10 cut.
Same point. Same point, same order sheet, same thing.
Yes, Mr. Chatterjee.
Lordship, that here. My lord, to meet Mr. Banerjee's first point with respect to, my lord, whether his application has been disposed of or not. My lord, this is an application which is dehors, my lord, the appeal, or rather the application which was disposed of. This application, my lord, he was not, if the appeal was disposed of, then this application would have been deemed to have been disposed of. But this is an independent application which is still pending, not taken up, my lord, by the court below. So the question of, my lord, if it is deemed to be disposed of, doesn't arise at all. In a pending suit, if the application is not disposed of and if the degree has been granted, it would be deemed, my lord, that the application, my lord, has been disposed of. But here is a situation, my lord, which is still pending. And I do not see, my lord, whether this application was ever moved by them, whether there were any arguments on this application at all. So they cannot, in the revisional application challenging a separate order, say that that application is deemed to have been disposed of. This is the first one.
Yes.
The second part of the limb of the argument, my lord, it's been vehemently been submitted before your lordship, my lord, that we have not used in opposition to, my lord, the supplementary objection.
Or Mr. Chatterjee, if it can be put it in this way, you did not raise any objection to the valuer's report.
I have
or
not
the
raised.
valuation
Yes,
So let us.
I'm on
that.
that. On that, I have not raised any objection to that. Now, my lord, there are two limbs of arguments in my respect to submission to that. First one is, I can show before your lordship that I was never given an opportunity to raise an objection. If he was, my lord, there in the, if the court was actually binded to look into that objection to the valuation report, then the court would have asked me to my lord, specifically file, and also he had to prove it by bringing that, my lord, gentleman who had, my lord, given that report in the box and allowing me to cross-examine it.
Mr. Chatterjee,
It had to be proved. Even if I don't put an objection, that valuation report had to be proved. This is one limb. I am not getting into that.
you have a right, you may say.
Yes.
You have a right
No,
to
the court,
cross-examine.
it is the requirement of the court. Because the court is accepting a valuer's report. It is a piece of evidence, nothing more than that. But if the court,
Mr. Chatterjee, it automatically forms part of the record.
if it automatically forms
Because
part of
it's
the
an
record,
ex-parte,
it's an expert, the
So,
court is
Order 26, Rule 10,
minded,
capital A.
my lord, court is minded to, my lord, look into it. It needs to be proved.
Mr. Chatterjee, the law says it automatically forms part of the
If
record.
it, even if it
You have
forms,
a right.
I have a right to,
You have a
say
right
that
to-
it is wrong.
You have a right to cross-examine. That's a different chapter.
Absolutely. Now, my lord, even if I don't file an objection, I had a
Even
right
then you
to,
have a right to.
cross-examine. That right was never, my lord, even given a semblance of a right.
You have also not said that I want to cross-examine.
No, my lord, the problem is here everything happened so fast because, my lord, of the earlier order
Yes. So, Mr.
of your
Chatterjee,
lordship. So now what happened?
none of you can blame the court.
I am not for a second. No, my lord, I
There
never.
was repeated directions that to
Never.
be disposed of. Both of you are aware. You are
The problem, this
appearing-
is where the problem is. Once a order goes from the High Court, they feel, my lord, that the rule of law has to be thrown into the Ganges, and whatever, my lord, is there on record, they will have to decide on that. And this is a senior officer. He needs to understand this, my lord, that what he is relying upon, if he is relying upon it solely and doesn't even question the, my lord, the person who's given that report as to the method on which he has arrived at, he doesn't even look into that. He says that this is gospel truth. Lord, your lordship, Lord, with a lot of, completely bow down, your lordship looked into that. There's one thing, Lord, your lordship, Lord, probably, Lord, overlooked is, he is given a valuation of the entire 13 bighas.
That I've seen.
So the valuation of 13 bighas and the valuation of, Lord, 22 kathas will be different. And I have with me evidence of what is there, my lord, in the market, my lord, in the surrounding areas. By Port Trust, none other than Port Trust, who is the richest landlord, my lord, in that locality. So these are evidences which I have. What Mr. Banerjee doesn't tell your lordship is that the entire property is acquired. So I have made a submission when I was forced to make that submission that he doesn't have a right to claim a single naya paisa. He has lost his right to anything, my lord, with respect to that property. And that is the subject matter, my lord, of the amendment which is pending before the court bill. And which has been spelled out in the objection to the application which they have filed, my lord, for releasing the entire property. That's a part of my objection. What Mr. Banerjee on the other occasion wanted to tell your lordship is we have filed an objection to that.
Mr. Chatterjee, anyway, you have no right with regard to the balance portion. Your claim is restricted only with.
I bow down. I bow down. But
whether
I
he
what
gets
I am trying to
released
say.
Or
Bow down.
it
There's
goes
just
to the
one.
state government or any.
There is one
requiring body.
submission that he cannot be unjustly enriched. he cannot be unjustly enriched. I have made
cannot
a,
be affected.
no, I'm not.
Whether he gets
I bow down.
possession or not, you
Completely
are not
bow.
affected.
I
by
bow
it.
down. But what I have said is that if the entire property is taken away by them, then my ingress and ingress to the property, that should not be, my lord, touched. And in the map, your lordship will see, my lord, that this is not a demarcated property. The entire property remains the same. And there are, my lord, the road which goes into, my lord, my property, my lord, that part, my lord, they cannot, my lord, my ingress and egress by taking the possession, that should not be affected. That was my objection to that application.
Your objection to that release.
To that release. Yes, yes. my lord. So that it is required to be, my lord, dealt with by the judge separately. My lord, if your lordship sees the map which has been given by Mr. Banerjee in his application, sees 106 once, 62.
Yes.
I'm sorry, not 106. It is the map is at 110. This is the entire premises 27 Nityodhan.
Yes.
Now, my access will to number 10 and 12 is, your lordship will find there are two accesses. I cannot by Mr. Mukherjee.
So the road is there. Your ingress
There are
and
two,
egress is
exactly, but this is not a demarcated road. This is not a demarcated road. Today, if the other shanties,
plots are demarcated.
yes, 10 and 12,
Yes.
Lord, what happens is the entire plot, then there are subplots made by the
Yes.
occupants itself.
Yes.
And this path leads to 10 and 12. So now what happens is, if they take possession, I have no problem on that. But if they dismantle it and the entire property, they start construction or do whatever it is, they can do whatever they want to. It's their property, if at all. My access to my properties should not be touched.
Road, according to
Yes.
you, this road.
My access
Access to the
to
main
10 and 12 should not be, access to the road, from the road to the property from the road. That should not be touched. And that's a part of my objection, which I have taken, my lord, in this application. And I've also said that they have lost the right to take possession because of the acquisition. That's a part of my objection. So this application, which my learned senior friend says is very easy, my lord, to be disposed of by your lordship, has certain things, my lord, which needs to be considered by the trial court. My lord, I had initially, if your lordship remember, said everything comes to an end if the application, which is the appeal which is pending, could have been disposed of. That was the initial order. They did not agree to that. They said that I will have to have money. If you have to have money, then you will have to show a right, existing right today, to have money. And that is a submission which was made by the lawyer in the trial court. If your lordship sees the first part, because today, if I have no right on the property, then whether I am entitled to get money out of even an application for stay being pending. This is a question which is required to be answered. I have obtained a degree, but that degree is nothing but a piece of paper. And if that piece of paper is there, you can't take advantage of that piece of paper and say that I will have money. This is one aspect in the matter. It's not that his rights with respect to the property is there, definite, and I'm wanting a stay. His rights to the property is inchoate, and that needs to be decided by the court, because I have raised a plea. One part of the matter. The second part of the matter, we have evidence on record where they in their balance sheet has shown this property, the assets, the valuation of this asset to be zero. No asset whatsoever. And why is that? Because they are aware of the acquisition. So what happens is, he gets money out of that acquisition, and he's also trying to get money out of, whatever he gets from me. Coming back to, the other limb of my submission, this is with the first part of, we'll come back at 2, then. And come back at 2. Come back at 2. Good. Where we go?
How much time will it take?
15-20 minutes.
How much?
May I come back at 3?
Otherwise, all the matters that got trapped.
And I continuing pattern.
Mr. Chatterjee is coming for the timing, my lord, I have cut.
Yes.
No, my lord, taking, my lord, from the argument of Mr. Chatterjee, my lord, I continue, my lord. My lord, the position is, my lord, today, my lord, the impugned order, my lord, which has been assigned by both the parties, my lord, only consideration by the on a trial court, my lord, is for the misappellate court is, my lord, with regard to the report, my lord, which is filed in the supplementary objection. And with regard to the other part of the argument, with regard to the release of the portion, my lord, to that portion, my lord, court has not gone into because it's a separate application was there, and against which there is an objection on record by us. Now, my lord, if my lord sees the orders, my lord, passed, my lord, after my lord has passed orders.
I'm sorry, my lord.
কাগজগুলো কোথায় যেন নোট করলাম?
I'm not going to trouble your lordship too much on merits.
Yes.
Now, your lordship, if my lord takes up the compilation that we've given. We've made a compilation.
Please give a copy to Mr. Banerjee.
Yes, yes. There's nothing much to show from there. Your lordship has seen everything. My lord, there's the only thing that your lordship kindly considers it that there is. Joshua Pradeep. Eight there now, page number. Now, with respect to the other part, my lord, I made my submission. I told your lordship what was there, which was required to be considered by the trial judge and not really, my lord, for the first time before your lordship. How much are they entitled to, my lord, get possession is something that the court needs to decide. That decision is pending because I have taken a point in my objection there. The objection which my learned senior friend.
That part.
Yes, my lord. Yes. But the objection, my lord, is.
111.
Yes, my lord.
Only that part that.
Yes, my lord. I'll just look into the objection once.
111 is your objection.
Yes, my lord. The second part, second page of that. কোথায় গেল রে?
1655
1655 yes, yes, yes.
111 of Mr. Banerjee's app.
Yes, my lord. Yes. Kindly turns over to page 113.
Yes.
And kindly looks to, my lord, that part. From the first line itself. Rather, my lord, I'll take your lordship back to 112 for the sake of continuation. The last line.
Yes.
The respondent number 1 petitioner is put to the strictest proof thereof. All those allegations are nothing but sheer myth and a clever ruse on the part of the respondent petitioner in order to escape from the rigor of law as well as to frustrate the hearing of the application under Order 6 Rule 17. Action 12 bottom. আমি এখন উল্টো দিকে চলে গেছি স্যার 113 in Miss case number such and such as the same is yet to be disposed of. It is stated in this connection that the execution case being titled execution case number such and such since been filed by the respondent petitioner is not at all maintainable in the eye of law, especially when the said execution case has been filed in respect of the entire area of 17 bighas appertaining to holding number such and such, in spite of having full knowledge that LA Collector Howrah representing the government of West Bengal had already purchased a substantial portion of the declared property containing an area of 0.384 acres from the degree holder on 10th of July 2020 in view of the order dated 31st of July 2017. So this is a dispute whether, my lord, this is correct or not. I am not, my lord, praying before your lordship that my lord goes into this. But this is a fact which needs to be adjudicated.
Oh, yes, last part.
Yes, my lord.
No other alternative way or path to be used by
my lord, absolutely, that's there 113 bottom. I have said that, and my lord, I did not make a submission, my lord, out of nowhere. It is all there. It is all there. So now today why Mr. Banerjee is saying, my lord, that this has been disposed of, because he doesn't want the court to look into this. There is a point which is raised by me. Good, bad, indifferent, my lord, that needs to be, my lord, disposed of. And these are all facts which are on record. This is not something, my lord, which is beyond record. Second part is, my lord, this objection which my learned senior friend gave your lordship on the first day was this objection. Because he had made a submission that I had filed a written objection against his supplementary objection. No, my lord, all the orders, if your lordship reads them, my lord, all are with respect to the applications which are to be filed. There was no order as such, my lord, asking me to file a written objection to the supplementary objection. And thereafter, my lord, going into, my lord, the merits, my lord, your lordship brought that point up, my lord, even before I could make that submission. So I'm not going to, my lord, waste your lordship's time. Your lordship has found, my lord, that what is the method, how 8%? How does the 13 bigas valuation, my lord, what little I know of, Mr. Banerjee, my lord, knows much better than all of us, my lord, even I would say, my lord, because he's much senior to everybody here, that it is from the rental value that the valuation, my lord, is, it's not the other way around.
Mr. Chatterjee, that Mr. Banerjee's submission is that
he cannot improve.
No,
he has said.
No, that is one way. He says he justifies that by saying it has been taken 8% of that to be the rental.
Exactly. So there is no basis on that. Today I could have taken, my lord, 20%. I could have taken 1%. My lord, to find out.
So he justifies by saying that
But he has,
in the Municipal Act it says
Mr.
12%.
Banerjee, being Mr. Banerjee, my lord, he knows best how to justify something which is not justifiable. I respect him a lot on that. So, my lord, my respectful submission is even Mr. Banerjee could not tell your lordship on the basis of what that the learned valuer, my lord, took 8%. Why 8%? Could have been something else. Or has he justified 8%? No. So these are questions which should have cropped up in the mind of the judge, my lord, before, my lord, getting into this matter at all. My lord, your lordship was my lord, opining to Mr. Banerjee, my lord, whether I will make a submission, my lord, that I will stay in the property without giving any money on. Ideally, no. I cannot make that submission. But due to the peculiar circumstances here, and I'm saying, my lord, that he has lost all right to receive money. And that is a matter which needs to be adjudicated upon. If today somebody, my lord, who is not in possession, doesn't have a right to the property, cannot receive a single naya paisa. Oh, judgment.
Yes.
Lord, Supreme Court in a very recent, not very recent, but a little older judgment in 2022, 18 SCC 233. Oh, yes, sir. Volume 18 SCC 233. Lord, there's a copy given. Lord, your lordship takes up my thing. Kindly have a look at paragraph.
You have given it earlier.
I'm told, my lord. But your lordship looks into it, my lord. I kindly excuses me, my lord. I just have one copy today. The boita under the key. Paragraph 100. Indeed.
This is well settled according to you. It should not be unreasonable or reach a.
Kindly reads on, my lord, to the next page. That it says that only the in a situation like ours, only whatever it was the rental should be paid. The next page, my lord, after paragraph 100. দেখো নিচে করে দেবো paragraph 100
That is an
Ah,
exceptional.
yes, exactly. And I'm trying to make out this case here, my lord, that this is an exceptional case. My problem is, my lord, I can have submissions on both accounts. One, that he can't have anything, and the other is, my lord, that it has to be reasonable. Amount of guesswork, yes, but there needs to be evidence where guesswork comes in. What would have been, my lord, they don't want the appeal to be disposed of, my lord, without me paying the money. They want, my lord, the money from me first. That's the order, my lord, of your lordship's last order. If that is so, they can't have both things together. They can't have the cake and eat it too. If they have elected that they will oppose
They
stay,
will do with the cake if they have, but they cannot.
no,
eat it.
you can't have and eat it too. Have is also eating, eat it too is also eating. This was very nicely put forward to me, my lord, by Justice Vishwanath Chaumanda. I made the same. I said, my lord, I have no clue. If I have the cake, I want to eat it. Well, you are Gaya and all those things were said. And then in very good English. And then said that this is the meaning of that word. That having and eating is the same thing. So you can't have the same thing twice. Twice. So that is why this is. So if you have elected to have this settled with respect to stay, my lord, then it has to be done, my lord, in a fashion known to law. If you are giving evidence, the evidence I have a right to, my lord, retort that. I did not have any opportunity as such, my lord,
To controvert
to
that.
controvert that. And I have evidence with me, my lord, to controvert that. So 2 points, my lord, if your lordship considers. First point is he is not entitled to single penny of money. The second point is, my lord, that even if your lordship holds or the trial court holds that he is entitled to, then I have a right to, my lord, oppose the amount that he has said is sacrosanct. Every order that my learned senior friend has shown your lordship is with respect to, my lord, the applications and their objections thereto. So I did not have, my lord, an opportunity to controvert that. There had to be evidence, there had to be, my lord, arguments on that, and then, my lord, come to a conclusion. No, I'm telling your lordship, my lord, that I have evidence about the area, about the amount of money that is there, my lord, in the amount of rent that is. Your lordship cannot look into that right now. I bow down completely. I am just telling your lordship I have it with me. So if I have a, my lord, an opportunity, I can make arguments on both counts. My respectful submission is kindly set aside this order, kindly sends it back on remand with a limited order. I'm not saying forever, but kindly directs the trial court to take evidence on this, allows me to retort whatever he has given, because it's by a private individual appointed by him. It is not a court's, my lord, court's order. If it was a court's order, then it would have automatically gone in. This is not a court appointed valuer.
So according to you, this is not an
Not a piece
appointment under order
under
26 will tell you.
bow down, completely bow down. This is not a court appointed, my lord, valuer.
So here he has to come
prove
to
it, doc and prove it. My lord, even order 26 rule 10A, it becomes only a piece of evidence.
Yes,
If
yes.
there also,
Considered along with other-
exactly, absolutely. There also, my lord, the author has to come and prove it.
Yes, because you, even if there is a report, you have an
bow down.
opportunity, you can produce some evidence in support of your case.
That was never given. Because there was an order or threat, my lord, from this honorable court, the trial courts forget that the rule of law is not above that. They will have to follow the rule of law, but within that periphery. And this is a
Times,
problem.
Mr. Chatterjee,
I
this
understand.
Fixing of
And
timelines creates.
this is the one, the biggest example. And it's not a one-off case, my lord. My lord, if your lordship today somehow asks anybody, my lord, in the trial court, there are matters which are being heard where there is a high court order. High court order mamla, high court order mamla. So we had laughed at one point of time when Justice Dipankar Datta had passed that order about Article 14. But in a way, now, my lord, it's becoming a probably truth. In a way, it's becoming correct. That
Only, I think in the last week I got a matter. Only plaint has been filed, issuance of summons.
and expeditious.
Date fixed for appearance, expeditious hearing application.
Because they know that if they don't get an order from the High Court,
Even
the trial
6
courts will not.
months have elapsed.
The trial
the
courts
date of
will
the
not
filing.
move if there is no order from the High Court. They are also not to be blamed. My lord, it's a very vicious circle, I tell your lordship. If anybody goes to the trial court, your lordship will find. Nothing beyond this. My lord.
Date fixed in the.
It should be there.
It's there.
No, it's not there. It's I hear it, Pilot. 21st May.
21st of May.
May.
For
The hearing of that application, Order 6 Rule 17 and all. And the releasing application also. Time binds it, whichever way your lordship feels, Lord, is best for the interests of justice. I will take, Lord, by 21st, I can file my affidavits and my, Lord, evidences.
If your lordship wants, then I can. Otherwise,
Mr. Banerjee, you have a right to reply.
yes. Lord, Lord, with regard to my lord, the right to cross-examine. Lord, my learned friend definitely knows, my lord, that in a case of local inspection commission and in the case of a investigation commissioner, difference are there. In the case of a local inspection commission, my lord, no question of cross-examination, that is an evidence on record. Now, Lord, if evidence on record comes in, they are not disputing that part with regard to the special officer's report here. Now, with regard to the engineer's report, Lord, he did not object to that in his objection. I repeatedly told, submitted before your lordship, he filed objection. Both with regard to the objection against the supplementary objection with the prayer made, as well as objection against that application. Therefore, my lord, and in the case of a cross-examination, my lord, your lordship knows, Order 26, Rule 10, Lord, it will be a 10-2, Lord, it will be a part of the record once the report has come. Now, Lord, if he wants to file objection, he can file objection.
If he wants to
In that
cross-examine,
case,
he can.
In that case, Lord,
With the
he is
leave of
to
the court.
cross-examine that witness.
With the leave of the court.
Yes, with the leave of the court. He is to that was not. Rather, his submission was, your lordship kindly look to the order. His submission, all objections have been submitted. That is his submission. That record was there. Therefore, my lord, the question would be that the argument that my learned friend has advanced, my lord, is that in the Order 21, Rule 97 petition, my lord, the question, only one question, whether he is entitled to obstruct the degree. But in silver line case, my lord, one line I may draw your lordship kind attention. I have given the silver line case.
Yes, I've seen that.
Lord, page, my lord, page 4.
Subtenant is bound by the decree.
Not only that, his question is, my lord, whether he is bound by the decree, consequently, whether his right to occupy the property is there or not, independently.
So
And he can
says,
obstruct it.
on the other hand, he says, since the property has been acquired, you do not have a right to execute that.
That is not the case made out in Order 21, Rule 97.
Yeah, amendment pen.
That is in the objection under Order 41, Rule 5. That is not the case under order. And my lord, answered that. Silver line case, my lord, it has been answered that. It is not required to be looked into other. Kindly look to paragraph page 4, my lord, towards the middle. In silver line case.
Yes. Page 4.
Lordship.
Yes.
The words all questions arising between the parties to a proceeding on an application would envelop only such question as would legally arise for determination between those parties. In other words, the court is not obliged to determine a question merely because registrar raised it. Lord, he is nobody with regard to the remaining property. That question, my lord, cannot be adjudicated upon under order 21 rule 97. He is concerned with regard to 12 kathas and 10 kathas. And then the question which executing court is obliged to determine under rule 101 must possess two adjuncts. First is that such questions should have legally raised, arising between the parties. And the second is that question must be relevant for consideration and determination between the parties. That is, if the obstructor admits that he is a transferee pendendility, it is not necessary to determine a question raised by him, as he was unaware of the litigation when he purchased the property. Similarly, a third party who questions the validity of the transfer made by a degree holder to an assignee cannot claim question validity should be decided during execution. Lord, these are the questions cannot be decided. Lord, appeal is a limited question. It has been summarily dismissed. And when it has been summarily dismissed, Lord, he is required to decide that. He is saying, with regard to, I am not interested with regard to here the appeal on merits. Lord, I was full at the time when, Lord, I submitted before your Lordship on the first day that the entire appeal can be disposed of. But when I looked into the depth, I have seen, my Lord, order 6 to 17 has been filed. Lord, it will not be disposed of one after another. Already 1 year has been elapsed. Yes. Already 1 year has been elapsed. Now, my Lord, another thing, my Lord, is if you obstruct, my Lord, his objection is that kindly look to that line only, my Lord. In his objection, page 111.
Yes. Yes.
Lord, relevant at page, my Lord, 113. Lord, so far the collectors, Lord, these cannot be decided in this proceeding under order 21 rule 97. Because, Lord, he did not take out take these questions in order 21 rule 97. And then, my Lord, he said that inter alia paying for amendment of the application is yet to be disposed of. It is also stated in this connection that apart from the property which is under occupation of the objector, as well as property which is under occupation of PXL, if the possession of the remaining area of the digrital property is allowed to be taken by the respondent by the execution of the degree, in that case, appellant will totally landlocked, especially when, apart from the portion within the remaining portion of the digrital property which is being used by the appellant objector for the purpose of their ingress and egress. That is totally wrong. Because the egress and egress has been mentioned therein, and thereafter road. And Lord, he wants that the entire, Lord, the conduct of the.
Where is their application under order 21 rule 97?
Yes, Lordship, kindly come to order 21 rule 97 application, page 51. Nothing. Lord, nothing with regard to that part. Whether he is entitled to resist the degree holder and to hold possession. That is the only question to be adjudicated upon. No other questions. On the face of the application, Lord, it is not maintainable in law.
So, Banerjee, please come to page 52.
52 years. 52. 52, my lord.
So, paragraph 2.
Seized and possessed the
Opposite party
appropriate
number
property,
two
inducted the petitioner as the tenant in
So,
respect of a
opposite party number 2 is
the judgment debtor. Opposite
he is the judgment debtor.
judgment debtor. Lord, my case is subtenancy created without consent. Lord, on that ground, degree was passed.
So, you obtained the degree against the opposite party number 2.
2. I obtained a degree. He has no right. One case is subtenant. Lord, next case is 34. Subtenant. Your lordship look into that paragraph 234. Subtenant of the judgment debtor, then judgment debtor inducted another subtenant. Who is the petitioner? What right he has got to occupy the property? Lord, I do not follow.
Ah,
21st.
For what?
My lord, for hearing of the amendment application, and my lord, there another application for release of the entire, that except 10 kata, 12 kata. My lord, and 4 matters, my lord, 14, 15, 33, 35.
Yes.
4 matters.
Your lordship is fixing on
20th of May.
20 of May.
14, 15,
33, 35.
14,
33 and
15,
35 action.
33 and 34.
33 and
35.
35.
Not 34, my lord, 35.
35, 33, 35.
33, 35.
এগুলো না একটা অর্ডার করে নিন these matters are taken up together. Call the next matter.
Order passed by my lord. Second of my lord.
So, Governor, if you want, you can address by sitting. Want, you can address by sitting.
Yes, I can.
follow that.
The Ganguly, the grievance was that the partition commissioner has not filed the report.
Yes, my lord.
See the report of the learned civil judge.
Report has been come.
No, not the report of the partition commissioner. See the report of the civil judge. I'm passing it over. Call the next matter. Please go through the report. Yes, call the next matter.
17.
Yes. Where is he? What happened?
My lord, the settlement talks have been fruitful, my lord.
Fruitful?
Yes, my lord.
So,
My lord, the total amount, my lord, they have agreed is 42 lakhs in 3 tranches.
so you have agreed to that.
Yes, my lord.
So give me the terms in writing so that I can.
My lord, then kindly keeps it next week, my lord. We shall come back with the
Why
terms.
next week?
My lord, for the day after. No, terms of settlement. No, the parties have to sign the terms of settlement. My lord, it can be kept tomorrow, my lord, at your lordship's convenience.
Tomorrow, all right. Tomorrow.
They are not there.
Who is not there? Sina will not be there. Why is also not there? Delhi. That cannot be a ground for adjournment.
But we can get the terms of settlement, but it can't be signed by the parties by today. Not be signed by both the parties.
Come on Friday
Very well.
on the prayer of the learned advocate for the
But I have seen it has not been submitted. You will kindly keep it pending before your lordship with the direction that might not be pleased to keep. But kindly keep it pending.
Mr. Ganguly, what I can do is, it has been stated that the learned civil judge has also requested the commissioner is not doing. Then you can approach. I will give you liberty to take appropriate steps for removal of that and for appointment of a fresh partition commissioner. It will be better. Otherwise, this cannot go on. In this way.
Well, I shall but keep the matter pending before your lordship. No, kindly. I beseech you, I love to kindly keep it. Otherwise, if it goes beyond, I am thrown in the wind.
Recording this, I will give you liberty to take appropriate steps. I cannot say that for removal to take an appropriate application before the district.
I can apply before the other district. Other district, Hooghly.
For what? For appointment of a
That's why, Lord. But we are,
I'm not saying anything. I'm leaving you open to make any prayer.
but we are kindly keep it pending before my lord.
Yes. 17 তো হয়ে গেল 17 টা হয়ে গেল ওটা তো শুক্রবার থাকবে কত নম্বর 18 yes
18. My lord, my lord, 18 is a related matter with 233. 233 is the main matter, my lord. When I filed the revisional application in 233 challenging the order, my lord, thereafter several one request was made to my counterpart before the learned trial court for prefer an adjournment. That was refused. So this is the second application out of the refusal.
Please dismiss. That is the impugned order. Everything goes.
No, no, my lord. Kindly,
What no, no?
my lord, kindly come to this. This is item 231. This is item 231.
Sir, please come to the impugned order in this civil revision application. Suit has been dismissed. What remains in the other civil revision application? The impugned order, what is the impugned order? Your suit has been dismissed.
My lord, kindly come to the typewritten page at 7 to, it is 30th April 2025. My lord.
30th?
30th April 2025 for evidence from the side of the respondent counterclaim.
Sir, prior to that, please read the first portion of the order.
Petitioner has indulged in dilatory tactics before the prayer time is rejected, no evidence being adduced, but the petitioner husband, this suit is dismissed or default to adduce evidence. My lord.
Then what remains? Your suit has been dismissed. What remains in the other civil revision application? Evidence is in the counterclaim. Counterclaim is a separate suit that will proceed. Your suit gone.
And my lord, this is section 24. My lord, then it is an incorrect order because it is an application. My lord, it is a section 24 application, my lord. The application was for section 24 filed by the husband, my lord. I prayed for maintenance, my lord. For that, I prayed for time, my lord, and that was.
Suit has been dismissed.
My lord, kindly come to this.
But the interim order, can that be gone into? Suit has been dismissed. Please consider the don't take any steps for the other revision. Yes, call the next matter. 19, yes.
The suit for partition, my lord. The defendant have stated that the plaintiff has no right to interest over the property in question. But at the time of delineation of the title of the plaintiff, petitioner, being the defendant, did not mention the what, through whom or how he became the owner of the property, a particular portion. That he wants to introduce. I am the defendant. In a suit for partition. The case of the plaintiff is that father, in the name of the mother, property was purchased. So
Mother died.
Mother died.
Mother died. So
Now,
mother purchased in the name of the mother.
Mother and both died. So now the heirs are become the owner of the property in equal share. We have denied the same. We have also said that you have no right to interest over the property in question.
Why?
Yes, because my lord, that up to that portion it was mentioned in the written statement. There was a deed of gift executed by my mother in favor of this son. Who are the different?
Favor of you.
Me and another.
So not the plaintiff.
Not the plaintiff. Plaintiff is the daughter. And also the property was purchased both in the name of the defendant and the father.
Which property? You said that it was purchased in the name of the mother. It's
Well, two properties are there, my lord. One is in the name of the mother, one is joint.
property has been gifted to two sons, excluding the plaintiff.
Plaintiff. The case of the plaintiff is that whatever property purchased is purchased to the money of the father. So, yes, to the fact who is getting the same, it is immaterial, according to the plaintiff. Our case is that this is property
of the mother.
separate property gifted, and another is the joint property which are purchased.
So plaintiff do not have any share according
Over the
to in that.
In that and the rest portion.
And in the other property.
Other property, she might have the shares, but what is joint property? Excluding 50%, upon 50%.
Other property I could.
Other property purchased jointly with the father and the one of the defendant, jointly.
Other property purchased in the name of father and one of the defendant.
So if that portion 50% will be in favor of the father, so upon this death, well, all the heirs will get.
Father has also died.
Now this is the case.
He has a share. So
To
what
that
is the
extent.
amendment for?
Amendment, I want to bring that the deed of gift and the joint purchase.
Joint purchase.
Yes, this is my.
You have not stated that in your
No, that was not there, my lord.
Why it was rejected after commencement of trial?
After commencement, and it is not necessary. I'll commencement of trial, I'll satisfy your lordship, my lord. There is something to say, my lord, after
Trial has not commenced.
commenced. But after that, to what extent the deed statement can be amended and how far it can be got into that came up for consideration with the Honorable Appeals Court, and considering the Honorable Judge, 9 points have been delineated. My lord knows
22.
Those points are delineated. So to some extent, some breathing space. I do. Now one can consider the trial court is of the opinion, yes, to try whether it is not necessary.
Show me your amendment.
Yes. Kindly turn to amendment, your lordship find, it starts from page 33. Schedule is at page 34.
Number 3 is the mother.
Yes, mother. Mother is alive. Mother is alive. Mother is alive.
You have said mother.
No, no, mother is alive. During your lifetime transferred. Father died.
So mother transferred in favor of one of the defendants.
One of the defendants.
One of the son.
One of the
You said
son.
two sons.
The two sons is the PSA. One and BS, I have not of that, my lord. So sons is a transfer. Now the trial court is of the opinion, it is not necessary.
The purpose of inserting this proviso, Mr. Raj?
My lord, the Appeals Court says for the.
You are making it frustrated.
Whether it is necessary or not, it is super partition. It is super partition. Even if, my lord, by way of, if I did not say, if I document evidence whether it disentitle me to prove my title, whether admission can
Well, I am for the defendant opposite party number one.
Lord, after a partition suit being compromised in a final decree form, Lord, I am facing difficulty before the court that whether the first, Lord, the complication is whether, Lord, this compromise needs to be engrossed by proper payment of stamp duty. But perhaps, Lord, the law is very settled. Even if the compromise ad idem, Lord, may I take your lordship, Lord? It's though, Lord, I must be candid. This application is being couched in a manner of expeditious hearing because the learned judge is being confused whether it at all it is necessary or not. Kindly once takes up the compromise decree, Lord, that is the certified copy, Lord, I believe.
Mukherjee, one application has been fixed for hearing.
But I'm coming. Yes, I know. But I'm coming. Lord, kindly once since September. Kindly looks at one order. Lord, kindly July. Lord, I will give that also. Lord, kindly, Lord. Otherwise, Lord, kindly see the order dated 27th of September 2024. I need one observation from your lordship's court. Otherwise, Lord, no, I have not. My application allow me to deposit the proper stamp duty. Lord, your lordship knows the stamp act given a provision of 0.5% of the excluding major share, I will have to put in. Lord, otherwise, this decree will become, Lord, nullified. There is a proper, Lord, time by virtue of which I have to do this. I apply to kindly see. That's why I invite your lordships. 27th of September 2024 order, the certified copy bunch, Lord, is annexed. 27th September 2024.
Third page.
But the second paragraph, your lordship, kindly read it. 27th September, latter portion, Lord. The second paragraph, your lordship, read it, Lord. I will leave your lordship. Leave to your lordship, Lord. This is which is, Lord. Thereafter, I filed, Lord, the event, the
Where is your application?
yes, page 39. This assessment is used to done by the Sherestadar itself.
Yes.
For this, Lord, everything.
This is, my lord, basically an administrative task, my lord. This has to be done by the Sherestadar.
Yes.
Because the valuation which has been prepared by the government, my lord, has already been deposited.
This application is pending for hearing.
Yes.
This is the court is
to him. He wants that to put in the stamp paper in terms of the assessment made by the sales data.
Yes.
Were you objecting to that?
No,
he is also not objecting. The learned judge is total confused. Kindly make one observation and dispose it of. Direct him, Miller, to dispose of. Kindly do that, Miller. Otherwise, Miller, this
This C says otherwise.
Lord, the C say where the final order affecting a partition.
Lordship, may kindly
First-
moves into my lord section.
Where is the instrument of partition?
Subsection
Lord,
15,
that
my
is
lord.
not the terms of compromise.
Only the decree.
Yes, decree.
So you have may not cover because please come to see where a final order for effecting a partition passed by a revenue or a civil court or an order such and such, keep that directing a partition is stamped. So final order directing a partition is stamped with stamp required for an instrument of partition, and an instrument of partition in pursuance of such order is subsequently executed. Then this applies.
My lord, instrument of partition, my lord, subject to correction made by your lordship also includes the final order, my lord, passed by a civil court in terms of section 2, subsection 15.
So if it is pursuant to that, you execute a deed of partition. Then this.
But my lord, once that our terms of compromise is made part of the decree, now kindly consider that thing.
This will not apply.
This is not a regular suit.
This will not apply. I'm telling you.
Why, my lord, I am taking the analogy. It is my instrument, that is the application which has been made part of the decree.
So Mukherjee,
there are, my lord, two views whether this was.
There are two things. If this is so, let us assume a case where parties voluntarily execute a deed of partition. And a suit is being filed, there the parties enter into a compromise, putting the terms. Is it necessary for a fresh instrument to be executed?
But if the instrument
not, for that, we used to advise in a different way for that. Please think over the matter. Prima facie, this will not apply. You may not be required to pay this. Prima facie. If no separate instrument of partition is not executed pursuant to the compromise decree. There is no necessity, Mr. Mukherjee. If compromise decree is all, where is the necessity for entering into a fresh instrument of partition? It says so. If in terms of that, you enter into a fresh instrument of partition, then this will apply. Otherwise, suit, decree, all, nothing. It partitions. Think of a case in a partition suit, final degree is passed. Parties accept, not challenged. Another, you have to put in further.
My hinge is, my lord, since it's a compromise.
What is the compromise, Mr. Mukherjee? Agreement between the parties with the seal of the court superadded to it. So even then you have to execute a partition. If that is so, then this. Otherwise, subject to correction, you are not required to pay this.
Because kindly remember that 2001 Supreme Court, in one of the judgment, the Honorable Supreme Court said, even if it's a compromise partition, then it's required to be. That is the hinge. That's why, my lord.
Then it is required to be executed. Show me the, that is why, show me the instrument of partition. That we have not done.
No, there is no separate instrument, my lord. Preliminary decree passed by the court. In the instant case, the preliminary decree passed by the court itself.
He says so. In terms of that separate instrument of partnership.
Here, my lord, what happened? May I just show before that? Preliminary decree passed on contest.
It's better if the court decides that.
Very well. Court has to decide it, not in either of the way.
Please don't invite the observations of these. I think it's better. Because you may not be required. Please apply your mind.
Very well. Lord, I shall do
Please
this.
apply your mind. If it is a compromise decree, you may not be required to put in this amount of. Because that is the reason why it was advised. If the parties amongst themselves settle, don't go for a partition deed, file a suit, get it compromised. That was the usual advice in order to save this. That is why when you said, it struck me. Looking at that application, why you are required to pay that? It's not required. I think fixed court fee is 80
Yes.
of the partition suit, end, nothing more.
Here, I shall.
Lost that capacity, Mr. Mukherjee, but.
Yes, that.
Complaint under the Consumer Protection Act 1986, the earlier provision.
How civil division is maintainable?
After the National Commission has.
Jurisdiction the appeal.
After that.
Further,
No further appeal.
Court is
No
not
further.
there. It's against the original order of the National Commission.
No.
Further
After
appeal,
state
the Supreme Court is against the original order of the National.
Yes, if the first on the pecuniary limit. Now, the compensation amount as assessed by the State Commission was reduced by the National Commission.
Compensation reduced. What is the dispute?
Now, the dispute was with regard to certain loan application made in terms of a scheme.
Bank.
Now, I'm not.
Who is for the bank?
SBI. I'm not appearing for the first time without a caveat.
Yes.
Now, I'm not quite peculiarly, the National Commission has held that the compensation or damages assessed by the State Commission is exorbitant, and therefore, despite the gross negligence committed on part of the bank, I am reducing it. But the said compensation or damages would revive if within 2 months the bank does not publish to the world that it was grossly negligent through newspaper publication.
What has been done? Bank published.
It's under challenge. Probably they have published in the meantime.
They have published.
No, that's under challenge.
Yes. That's under challenge. It does not stop you from challenging. It's not that. But what was the original compensation amount?
50 lakhs assessed by the State Commission, reduced to 25 lakhs. If within 2 months this is not published by the bank, then it is restored to 50 lakhs. And what the impending loss is loss of.
Show me the order of the State Commission.
Loss of title deeds.
Loss of title deeds.
Vis-a-vis not non-granting of the loan. Gross negligence clearly found out.
What was the compensation directed to be paid by the National Commission?
25 lakhs.
And the State Commission?
50.
So, Majumdar, really you want protection of your title deeds because original has been misplaced. So
that's one aspect of the matter.
Yes.
The second aspect is not the loan. I was persuaded, I altered my position irretrievably so as to pursue this scheme as floated by the government of West Bengal to set up a small scale industry.
Mr. Majumdar, can one way or the other the appellate forum has considered that.
Right.
So it's only assessment with regard to the compensation part.
Not the court
forum assessed it in one way. The appellate forum, being the final fact-finding authority, has assessed that.
Right.
Whether under 227, that exercise of discretion, if perversity could not be.
That's the perversity. Please come
to the perversity.
Please come to paragraph 9
of the
Commission, National Commission's order.
Please show me
of the impugner.
State Commission's order operating part first.
Please come to page 391 at 402.
Yes.
In the light of the foregoing, we are of the considered view that the OP number 1, namely State Bank of India, having its central office at Mumbai and one of its branch offices at Midnapur town, commonly known as SBI Midnapur branch, is clearly responsible for deficiency of service and negligence on its part in not processing the complainant's loan application properly and in time, and also in not conveying its final decision thereon, even after lapse of more than 3 years from the date of application, and was
the loan amount sought for.
It was a loan amount was sought for roughly, if not 15 or 16 lakhs of rupees, and I invested. Yes, that was a scheme, and not 4 lakhs I had invested, with security of title deeds.
For that 50 lakhs, Mr. Majumdar.
It has granted. The bank was only aggrieved by I can show to your lordship, the dichotomy in the stand taken by the bank. In fact, it is a clear case. In fact,
found that there was deficiency in service on the part of the bank.
I would have advised this client to go a step further and not invoke the jurisdiction of RBI to take action against SBI, invoking the Banking Regulation Act. The bank, being SBI, takes a stand before the appellate forum that the stand taken before the State Commission was wrong. But
this compensation of this, it's after all a public matter.
Please come to 403.
Public money. So, but you want protection of your loss with regard to the title deeds.
And
must be some.
Please come to 403.
To compensate your.
Yes. No, please come to 403.
Yes.
And Khadi Village Board so and so, in appeal number so and so, the Honorable National Commission, where the facts have a line of similarity, we consider that the ends of justice would be best met if an amount of compensation to the tune of 50 lakhs, considered fit and proper in facts and circumstances of the case, and being punitive damages as provided by the complainant by swearing an affidavit.
What was assessed, Mr. Majumdar?
Not there.
50 lakhs.
Yes.
What was
not,
the basis of assessment?
not there was a clear cut, not the investment. Number one, not there was a chartered accountant certificate vis-a-vis the scheme and the amount that I had already invested.
Show me your claim
And-
for damages.
And not, that was not even disputed.
Show me your claim
Yes,
for
not
damages.
please come to. Not I just not come to that complaint first.
Yes. How have you assessed your damages?
Yes, not please come to page 141 in the first volume.
One 141, and this is your
This was supported by my pleading in the complaint.
estimated profit.
Yes.
When you applied for the loan,
2004, 2003,
2003, and when you filed this complaint,
2008.
why this delay?
Not when the scheme was terminated.
For 5 years, Mr. Majumdar, you could.
The scheme got terminated in 2008.
Maybe. So nothing prevented you from approaching
No,
the
2000
authorities prior to that.
It was a sponsored scheme
So
of
you
2004.
When the scheme will lapse, then you will come to the court.
2004, the scheme was promulgated. 2005, there was an
approach during the time when the scheme was in force. Something could have been directed.
No, please take.
So maybe whether you had any intention to take that loan
No,
is
I had-
also to be
I
considered.
had invested. That's a clear-cut finding. I had invested.
Where?
But in terms of the
Maybe-
scheme.
Mr. Majumdar, kindly consider a person who wants to do a business, applies for a loan in 2003 under a scheme, will wait for 5 years till the scheme is then coming
The
applying.
in principle approval was granted in 2005.
Yes.
Then not
Even after that, when the scheme, so you waited even thereafter 3 years.
2005, the in principle approval was granted. Thereafter, I had to execute not in terms of the scheme. This was completed by 2006-7.
After 3 years.
2006-7. Then not the Khadi board had to step in because it was a scheme to be sponsored by through the Khadi board. Khadi board sponsored my case. Thereafter, it had to be fructified. It could be fructified only. When it came to the disbursement, they said that I have lost the title.
You have calculated your damages for the profit of the last 5 years.
No,
Or
no.
for waiting those.
Other
5
aspects as well.
years.
This is one part of it. Please come to 142.
Yes.
It goes on every aspect of the investment and not the scheme and the phases of amount which the government would release with the applicable rate of interest. But the scheme amount would not come to me in one go, it would come in phases. After every phase that I complete the.
I appreciate that.
That's it.
When the first installment is not coming and you have applied in 2003 and you have waited for 5 years.
2003 was
The scheme was withdrawn.
the scheme was withdrawn in 2008.
What is the date and when you have applied?
When I made this complaint in 2000, no, I applied in 2003 itself.
You file an application before the.
So the complaint before the commission, no, the exact date I'll give you, Lordship. Complaint.
Yes, after it was withdrawn.
Of course, yes.
Then
Date,
shows
date,
that you have
actual
the
date.
intention to do
Actual
it.
date.
After it was withdrawn, what purpose? They cannot now sanction you.
No, I applied on
The scheme
30th,
was non-existent.
30th of May 2008.
13th of May 2008
Yes.
is the, you have applied.
Applied for the,
And scheme was in force still.
this was, I'll give the exact date.
Prior to that,
Must be a month.
At a point of time when you approached, you knew that
But I could,
not be getting
but I
paid.
approached the authority for a compensation only after I would come to know about the loss suffered.
What prevented loss?
Not one is not I apply under the scheme or I apply to the court for the purpose of.
One is for compensation.
Right.
Other is that your intention to proceed with that.
Yes.
That intention was lacking, Mr. Mujumdar.
Please come to me. I could not have foreseen that the scheme would close down or the government would extinct the scheme, make the scheme extinct. Please come to page 36.
So there is under Article 226, 227, there is no prescribed period of limitation. Isn't that delay and laches?
Not your lordships, not on that side.
Reasonable time you have to
Not on that side, your lordships have seen that WBIDC schemes. Has seen that WBIDC schemes. Not how many times the employers had to approach not for the purpose of expeditious inspection. Till such time as a matter of policy in 2025, the government has decided to withdraw all policies.
Checking here, you did not take any.
No. So those were in phases. Not I can show the BDO had allotted the land, so that took some time. Then not came the question of in the Panchayat sanctioning the construction plan. That took some time. Then came the question of not the land being developed. That took some time with investment. Then comes the question of not in principle approval by the bank.
The National Commission's order.
Yes, please come to not the impugned order. Lordship may straightway come to paragraph 9, internal page 11. And the pagination is down below right hand side.
Page 11.
On the other hand, has your lordship got that?
Yes, yes.
On the other hand, there are manifest contradictions in the version of the appellant bank. What is the nature of contradiction? It has been brought to our notice that the complainant had submitted all the requisite original documents being the project report, affidavit, original validation report, original title deed and record of the property, apart from the original MSME forms under his separate letters of 2004 and 2006 respectively. The receipt of which original documents was duly acknowledged on behalf of the bank, but the same were not returned to the complainant in any event.
Sir, Mujumdar, the order of the National Commission protects your right in a much better way. Much better way. Because kindly take up the State Commission's order. Please take up 403 or yes. It only says compensation, nothing more.
Interest.
Yes, yes. Mr. Mujumdar, what is your ground is that your original title deeds have been lost by the
and also not the other aspect. Also the investment with relation to the project.
But the main thing here, State Commission did not protect you on that. National Commission, please come to the operating part of the National Commission.
Yes,
it says
give a declaration.
They have to acknowledge certificate of to the complainant acknowledging the loss of the original. This is very much important because in future, if this is there, you can also mortgage that, otherwise not.
Please come to
by the bank personnel also publishing a notification. The well-reasoned order, Mr.
Please come to paragraph 11.
Your interest in a much better.
Please come to paragraph 11.
Reducing the amount of compensation, but this is.
Please come to paragraph 11. Not what is the logic? No, please come to paragraph 11. The deficiency in service on the part of the bank is 11.
Yes, yes.
The deficiency in service on the part of the bank is therefore clearly untenable.
Untenable.
Clearly untenable. Deficiency is untenable. Should have been 10. Should have been 10.
So there is no deficiency in service.
It nevertheless has brazenly sought to deny that it had ever received any original document from the respondent. So not a falsity sought to be projected before the National Commission is disbelieved. Whereas its own chief manager had stated in his affidavit in the Learned State Commission that the originals were given back to the complainant without any acknowledgement. Such manifest contradiction in the stand taken by the bank, qua the non-receipt on one hand, the alleged return without acknowledgement of the documents on the other, cuts at the root of the defense raised in the original complaint. For the aforesaid reasons, this commission finds no tangible ground.
Sir, this order to be set aside to the State Commissions to be restored. Please think over the matter.
No, please take only one. Since it can.
I appreciate, yes, all observations are in your favor. I'm asking you, you want that the state commission's order to be affirmed and the national commission should go.
Not in,
Please apply your mind.
no, I got to get a flavor of your lordship's mind.
Have both.
Vis-a-vis
You
the
cannot
title
have
deeds,
both.
vis-a-vis a declaration to the world as regards my title deeds. Now please
That
come
is
to,
much more important than that 25 lakhs.
please come to paragraph 13, 12.
Yes.
Since it cannot be denied that if the original title deeds are not returned to the complainant, economic or financial loss which could be caused to him by way of fall in value of his properties in case he needs to sell the same for valuable consideration
Why? These
cannot
have
be,
been protected. This value is much more than 25
yes,
lakhs.
see, cannot be properly assessed or calculated.
That is why.
Nevertheless, an award of compensation to the tune of 50 lakhs flat would appear to be somewhat exorbitant. Now, please come to this next sentence. Now, this loss caused is not only on account of title deeds, but assessment is also in terms of loss of business. Such compensation is therefore ordered to be reduced to 25 lakhs instead, subject to the condition that the bank shall issue proper certificate to the complainant acknowledging the loss of his original title documents including title deeds by the bank's personnel and also publishing a notification in that regard in the local English. What is that? The bank has lost my MSME certificate, has lost my MSME credentials. Also, local English and vernacular newspapers.
Much important, Mr. Bojumdar. This publication in the newspaper, so this protects your right in a much better way than that 25 lakhs.
Now, please see what is the consequence of non-publication. Please see the
Well-reasoned order, sir.
so what is the consideration? Is the value of the or is the quantification or consideration for damages get reduced by way of or by reason of the bank being given a chance to declare to the world that it flawed?
Mr. Mujumdar, that's other way. It's protecting your interest. Otherwise, if that is not there, only state commission given you 50 lakhs, will get trouble everywhere. Even if you want to sell, if you want to take loan, but this will protect your interest.
Not
It's
20
much more than that balance 25
but
lakhs.
25 lakhs is not the value of my property. It's more than crores.
That is why I'm saying.
So
that is why I'm saying it's much more than this 25 lakhs.
now please see the next sentence. Not what does the appeal court do? Not the appeal court can give reasons, but what the trial court could have done, the appeal court could also do. Now, what is the consequence of non-publication? Please see. Acknowledging the loss of his original documents, including title deeds by the bank's personnel, and also publishing a notification in that regard in the local English and vernacular newspapers having wide circulation in the area of Midnapur and its vicinity in West Bengal at its own expense within 2 months from the date of this order.
Yes.
Failing which, the compensation amount of 50 lakhs awarded by the State Commission shall
Yes,
not
this
be
is the
reduced.
condition. So this is the condition. 25 lakhs. If you do this, then it will be 25. Otherwise, 50. So that's the consideration, protecting your interest.
Now,
in a much better way.
now not in that process, what has been done is that the valuation of the property has been resembled by a figure of 25 lakhs. The value of the property has been probably, it's not a compensation in that way.
You can take it in the other way. So the valuation of your property as made by the state commission was only 50 lakhs. Now, the commission has protected you to the tune of your
But
value.
the State Commission was only considering deficiency of service and it was not considering the valuation of the property, first of all.
But this protection is in the interest of your client.
Right.
Please apply your mind.
But the bank, the National Commission had replaced
If you
this.
want, then I have to say that state commission, if it protects your right, if you want that, you will your interest will be protected with that 25 lakhs.
But I go by that. Not I go by that instruction. Not my client has, when Mr. Mukherjee is here, he says that he is agreeable to forego that.
For what?
Not forego, not he stands by the State Commission's order.
Now they have made that notification.
Not might have, not anybody who is complying with that, not, it's always subject to the.
It's not that. Now you are protected, Mr. Then you have to, they have to state that no.
No, that's No, no, compliance,
Take this, Mr. Majumdar.
no, no, compliance is always subject to review, or not proceeding. Same with a contempt jurisdiction, complaint come up in appeal before your lordships, no, that's always permissible. Now, please see, failing which the compensation amount of,
There is no question of stay here.
no, that's nothing, not,
You serve, let them come.
not the next sentence says, in either event, any delay in payment of the original or reduced compensation subject to compliance of the direction shall attract 12% per annum instead of 10%.
So everything, if they fail, all sorts of protection has been given. That is why I'm telling you, it's a very well-reasoned order protecting the interest of your.
But even not the 2010 order of the State Commission, which granted 10% interest, would take me to another 35 lakhs straightway. This has not been replaced. This has not been replaced.
But a party has a right to prefer an appeal.
Right. Now, that part of
Right to prefer an appeal, they have preferred an appeal.
the National Commission has not reduced that, not touched that part of the order by which interest was awarded.
Yes.
So that 10% remains, but whether they have complied with it or not, we shall find it in the execution proceedings.
Yes. So that that has not been touched. Only you are aggrieved by this reduction of
by 25.
This 25 lakhs. And the other
and not
aspect
this
is
that is considered, but this valuation would today come to 2.73 crores. If not, the valuation of the property is sought to be protected.
now who will pay this amount? Why from the public exchequer?
Not
bank is dealing with the public money.
Bank deals with public money. At the same time, not bank has its own sundry account for the purpose of doing away with these mischiefs.
But for what? From where does the sundry accounts come? After all public money.
Right, right. Not say Reserve Bank. No, Reserve Bank does not do any banking business. How does it survive? It survives on supervision charges. It's also part of public money. But not when the bank has been brought within the parameters of a deficiency of service in terms of a special statute. And
that has been done. Mr.
But there are truths. Not
done. It's not that your case has been accepted or your allegation with regard to the deficiency has been accepted.
It's not only
with regard to the quantification of the compensation.
Not the, in fact, not the appeal court. I mean,
the question will come. What was the basis adopted by the State Commission for assessing that 50 lakhs?
No, that they have accepted. This 25 lakhs they have accepted.
50 lakhs.
That's right. No, that has been
50 lakhs. That has to be taken into
yes, that has to be considered. No, that has to be considered, of course. Not whether
you run the risk of the other side challenging this.
Not if they have not challenged, then not,
They can at very
if they have not challenged.
Yes.
Madam, my lord. It is arising from an application of section application of maintenance liability under section 24 of the Hindu Marriage Act. In a proceeding, as it was registered as a miscase in connection with the proceeding for restitution of the conjugal lie filed by the wife opposite party. Wife opposite party filed the application for restitution in 2023. And I filed a suit for divorce in 2021. Nothing was filed from 2020.
What is your challenge? What is your
challenge? Is that main point is that
husband.
I am for the husband. The wife stated by specific averment in the application for maintenance liability that I am working as without no work, no pay basis as a contractual employee in a school, not mention anything, and I am not getting too much, and that is the basis for his this demand of
claim for mandatory liability, I cannot maintain the litigation expenses, etc. That was denied by the husband, by the specific government. Then the affidavit of assets and liabilities were filed, and it was observed. The wife acted with.
Your salary?
My salary is 34,000 and odd.
What are you doing?
And I am a junior clerk in the railway. And my wife has suppressed the fact, totally suppressed the fact. She has. And having a good bit of income.
There is substance in the argument made by the learned.
Gratefully, Lord. Yes.
My lord, 23 to 25 can be taken up together.
Gratefully.
The issue involved is same, my lord, is that the claimants and application under section 5 referred by the claimants were allowed in an application under 166 of the Motor Vehicles Act.
Cannot be allowed.
Post 6 months. There is a provision under 166(3), my lord. The issue is also res integra before the Honorable Supreme Court, and incidentally it is fixed today also for hearing. This is the order, my lord. Supreme Court, my lord. On the same issue, 166(3), my lord. Because various high courts have come up with various decisions. Some have allowed, some have said no, this is mandatory. So this was not taken into consideration by the trial court.
Did you place this?
My lord, this was, yes, the learned trial court was not oblivious of this. He was aware of this judgment, he was
Show
aware.
me that you have placed this judgment.
It's not a judgment, actually, it was pending then.
Show me that you have made this statement that this matter was pending before the office.
My lord.
For 8 days delay condoned in a motor accident claim.
My lord, 166(3).
Insurance company.
I understand, my lord, but 166(3) says it's a man.
Show me 166.
Yes, my lord. My lord knows that this has only come into effect of the 2019 amendment. Since, my lord, it's still there before the Honorable Supreme Court, let this issue be left open. I'm not saying that let that issue be closed. Let that be opened, subject to what the Honorable Supreme Court holds. That is my humble prayer.
This issue was not decided by the High Court.
This is possibly the first time, my lord, I have come up. I don't think this has come up prior.
Sure.
I'm not very sure of this, but
How many matters you are moving?
with regard to this issue, these are the three, my lord. So I'm not
Other
aware.
three.
I'm not
Let me
aware.
see the other two.
And my lord will also consider the way this section 5 was allowed. If my lord kindly takes up the revisional application number 1610, the first one, and come to the impugned order once, my lord.
Please keep in 1996 4 SCC 652.
But I don't have it right now, my lord. But that was
the matter
prior
you
to
have
the
filed.
amendment. That was prior to the amendment, my lord.
That
was prior to the amendment. I've taken that
I've
pleading.
asked you
This was prior to the amendment,
I've
my lord.
asked you have said no in this.
This was prior to the amendment. Amendment has come in, my lord. I don't have it.
That.
I have taken it
That
my
is the
pleading that
decision
this
which
was
the Honorable
considered.
Supreme Court has the learned trial judge has considered.
Yes, my lord, but this was.
Please show me the
I don't have the judgment right now. My lord, kindly grant me some time. I'll come up with the judgment trial to distinguish on the very fact that this was much prior to coming of this 166.3. This has come only in 2022, 1st of April 2022, after the 2019 amendment, my lord.
Claim petition was filed. After that?
Yes, much after that, my lord. That is why we are pressing. Otherwise, we won't have. Much later, my lord. Kindly see, this is of 2023, MSCC number 432 of 2023. I can only take this point if this case is filed beyond 1st April 2022. Otherwise, I can't take this point. And moreover, my lord, since Supreme Court is sitting over this, my lord, I am not saying that it ought not be allowed. I am on this point that this point be left open.
Of pendency of a special leave petition.
My lord, I am not onto that.
Presidential value of other judgments.
I agree to that. I agree to that, my lord. But only one thing, my lord, let this issue be left open.
Because an issue is pending, all things that will be stayed.
No, I'm not asking for stay, my lord. I am only saying this let issue be left open. The court has concluded this issue by saying that my section 5 is allowed and this subject to the outcome of this appeal, my lord.
Then petitions will proceed.
Yes, but subject to this
submission. I'm recording that.
My lord, I cannot ask for a stay. My lord, my lord knows the beneficial legislation. Even if I ask for a stay, my lord will not be inclined to grant me a stay.
I'm not for that. According to you, you say.
No, I'm not according to me. I'm not according to me, my lord. No, my lord. Kindly not embarrass me for my client, my lord. I have not said that. What I am saying is let the issue be open, my lord. They have closed this issue and also kindly see how they have considered this section. Kindly takes up my revision.
Of Section 5 application, if it is not closed, what will be the effect on the main?
Hello,
Can it proceed?
No, it can't, my lord.
Then,
actually, it can't, my lord.
Then, what could the learned trial judge do?
But by deciding the section 5 and kindly see the reason. Kindly takes up my revision 1, the first revision. Kindly see what the reasons are seen.
Yes.
For the ends of justice, the petition under section 5 of Limitation Act is hereby allowed. No reasoning, my lord. Absolutely no reason.
Supply the reasons.
And the other two, they have
gone on the reasoning part.
But the problem is appearing for insurance company. We always seem like we are wearing a devil's. It's not like that, my lord.
After all, this is a claim petition.
I understand, my lord. I understand, my lord.
So,
but my lord will kindly not dismiss my revisional application because the Supreme Court is kindly some observations, my lord.
yes. Next.
26.
You are appearing?
Yes, yes, ma'am.
Yes, yes.
An order of demolition has been passed at page 39.
Order of demolition?
Yes, already passed. Now against that,
You have made an unauthorized construction, it has to be demolished.
has to be demolished. I have, this is my allegation. Now the miscreant has prepared an appeal which is pending for last 2 years, record not yet received by the client. That is the, I have annexed the entire order sheet. Kindly
Can
see
be
that.
done.
And I am only one secret direction from your lordship so that a direction will be given to the register. It will be hard out, my lord. Because it's dilatory tactics are dragged.
Yes.
Against the order, my dismissal or misapplication not. I am before your law, the appeal preferred, appeal was also dismissed.
What is the miscellaneous appeal for?
Not the miscellaneous application, it was initially not for determination of my status, not since the decree was for the opposite party number
Determination of your
status in respect to the property. Not what happened, not the present opposite party number 1 filed a suit for eviction against opposite party number 2. I was not a party to that suit. Not I. It was exclusively not the collusive suit between the parties. Suit was decreed. You'll also kindly take trouble to look to the judgment.
Now, what did you do after that?
Not the I was not aware of the fact. The execution case filed in order to give effect to the execution proceeding. Lord, I came to know. I filed immediately an application order 21, Rule 98, 97, 98, 99, 101, 103, reduced section 151. That was not rejected. Against that one, I preferred an appeal. It was also rejected without determination of my status in respect to the property. And since I was not a party to that suit, the property exclusively owned, possessed by me, I am running business over there.
How a civil division is maintainable? It's a deemed decree. How a civil division is maintainable?
Since it has been passed in a proceeding.
Not a order passed under order 43.
Not the
order 21, rule 103. It's a deemed decree. Second miscellaneous appeal will lie. Not a civil division. Committee will lie.
In that case, it can be converted to that.
Wherein the application has been adjudicated upon under the order made thereon shall have the same force and be subject to the same condition as to an appeal, or otherwise as if it were a decree. So like a suit, first appeal, second appeal. Has to be a second miscellaneous appeal. After some argument, the learned advocate appealing for the petitioner.
No, I've got a petition. Against the order of the Alimony painted a light. The petitioner, because lordship is the wife, the husband is a renowned doctor. In the year 2014, the husband took a rented accommodation to attend these 3 chambers and started to reside in a rented accommodation. After 2 years, he filed a suit for divorce on the ground of cruelty and desertions. And that since 2013, she paid rest 11,000 per month to the wife. But in the year 2018, she stopped payment 11,000, instead started to pay 3,000 rupees only. Against that, an application for interim maintenance under section 24 has been filed, claiming 40,000 per month and litigation cost of 50,000. The learned judge passed the order of payment of only 7,000 per month on the ground that the wife is a highly qualified lady, but she did not took any employment. Without considering the fact that he has 2 daughters, 2 sons, 1 son and 1 daughter, she had to look after them, and her husband was transferable job. Last post is a medical associate professor, Medipur Medical College. And his income is much more than 2 lakhs per month. But without considering solely rely upon income tax.
Finding of the learned trial judge with regard to the income of the husband.
May I kindly see the order?
Son is employed.
In a page 3 of the order input.
Son is employed.
Son is employed, Lord. monthly income is raised 19,800 on the basis of income tax certificate.
Husband is residing in a rented accommodation.
Yes, my lord.
Wife is residing in the flat of the husband.
Yes, that deserted husband. Husband practiced for 3 chambers. For that, he took a rented accommodation nearby 6 chambers. After 2 years, he filed the case on the ground of duress and cruelty. And in the meantime, since 2014, she paid rest 11,000 per month. But in the year 2018, he started to pay only rest 3,000 per month. And the findings of the Lanera is also self-contradictory. On and kindly see page 3. In page 3, second paragraph.
Judgment says if wife is a highly qualified person, she has.
No, my lord. But her husband prohibited him to take employment. First of all, and second of all, her husband was engaged in government hospitals, transferable job.
Yes, Lordship. This is the suit for eviction. We are the defendants. There is a paradoxical findings. Kindly come to the impugned order. Last 3 paragraphs.
Yes. Which page?
Second page, last paragraph. Needless to mention, it is the duty of tenant to pay the rent to the landlord in a continuous and regular manner without any default. In instant case at hand, considering the above mentioned facts and circumstances, it appears that there is a subsequent default in payment of rent to the landlord by the tenant for more than 4 months in a period of 12 months as per the provision of Section 74 of WPT Act 1997. As such, the substituted defendants have no relief against the order for delivery of possession of the premises to the landlord. However, the defense of the defendant is not struck out.
You are for the landlord.
We are tenants, substituted tenants. Actually, suit for eviction, original defendant died on. And thereafter, substitution was there.
No, how are we aggrieved? The defense has not been struck off.
Defense has not been struck off, but we went to rent 10 months on act occurred due to death of the original tenant. Thereafter, substitution was there, but the substituted defendants have not got any summon. This is why they have paid area rents on application on their own accord. And they were contesting the suit.
When
Lordship,
were you substituted? When were you substituted?
Order 82, Lordship, in petition.
When was
paragraph 8.
Paragraph 8, yes.
That from the said information slip dated 21/4, since the substitute defendants had not got any summon, and the petitioners came to know that in the meantime, opposite party plaintiff had filed a substitution petition for incorporation of their names as legal heirs of the said original defendant, and after disposal of the said petition, the learned court was pleased to pass an order of substitution by order number 82 dated 16/12/2019 and gave direction to the plaintiff opposite party to take necessary steps upon the substitute defendants. But no steps are taken for service of summons upon the petitioner as substituted defendants. This is a area rent occurs, and they have paid the area rents through challan after appearing in the suit.
Yes, so there is no default.
We have no default, but in kindly come to the impugned order. We have no default, we have paid, and 7172 already complied by the original defendant also.
He has also been rejected. Why are you aggrieved by this? I cannot follow that.
Now kindly come to the order. invocation of section 7(4), how it occurs, Lordship?
You are aggrieved only by that. I'm
Only-
clarifying that. I'm only clarifying that.
Okay.
7(4) cannot be, 7(4) is a different thing altogether.
Lordship,
I'm only clarifying that.
Lordship.
But where is your challan showing deposit of 42,188
All the challans is annexed here.
to 188 pursuant to the order of the court? Pursuant to the order.
Lordship,
140.
Lordship, after appearing, so motu application, and we have submitted the challan area.
That challan, show me that.
Yes,
Depositing 42,188.
Lordship.
Where is that?
Lordship.
By the order imputed.
Much obliged.
This is my application, my lord. Why dependent in a matrimonial suit filed by the husband, opposite party is the petitioner before your lordship.
Yes.
Petitioner application is directed against an order passed in a proceeding under section 24 of the Hindu Marriage Act filed by the petitioner, my lord. Why filed a suit for divorce on the ground of cruelty and desertion, my lord? The learned trial judge, while adjudicating the application under section 24 threshold, reject my application for maintenance on the ground that there is no huge disparity between the financial status between the parties, my lord.
You are earning.
I am a para teacher. I am earning 13,000 per month, my lord.
What
While
is the income of the husband?
husband has a BTech qualification, has a information technology. He has disclosed that he has a business of two-wheeler vehicle garage, my lord, and her income is monthly 11,000. Without any cogent evidence, my lord, without cogent evidence filed by the affidavit of assets, my lord, kindly consider. No bank statement, no ITR, no PAN is filed. Without any cogent evidence, learned trial judge has threshold refused my application, my lord. My lord, kindly see, if according to the Rajneesh versus
Finding of the learned trial judge with regard to the income of the husband.
kindly come to the internal page, last page, my lord, page 2. My lord,
Yes.
second paragraph, it is admitted position that the petitioner is legally married wife of the OP. It is not in dispute that she has residing apartment since long. In the written objection dated 30th March 2019, opposite party has claimed that leaving Kolkata, he has shifted to Agartala and is earning rupees 5,000. Initially, he has admitted that he is doing tuition. At that time, at that point of time, he is earning 5,000 by imparting private tuition. Subsequently, affidavit of assets and liabilities dated 17th December 2022 has been filed. In this affidavit, he has claimed that his income from his two-wheeler repairing garage. Kindly consider he is a BTech and in information technology, while he is admitting that he is doing income from two-wheeler repairing garage, rupees 11,000 per month, besides MIS of rupees 1,000.
What can be done? He may not get a job commensurate to his qualification. That also happens.
He said, according to the
Highly
Roswell,
qualified wives, they are also not getting jobs.
this is not bad. This is not while husband wife is incoming, some income has there, that is not huge amount. My lord, 13,000 per month. Is a para teacher. He is not assistant teacher. He is a para teacher. At this stage, my lord, 13,000 is not sufficient. My lord, kindly consider.
Independent income.
My lord, kindly, only litigation cost 1,000. I have paid for 1,20,000. Litigation cost 2015. The application was made and 2000.
Madam, it's sufficient. It's Next, call the fixed matter.
T24.
Yes. Yes. So, sir, you have made your submissions.
If anything reply matter, if required matter, if required matter, give reply matter, kindly give that option.
What required? You are physically present. Mr. Odhikari was virtually.
Is making some new submissions, if some replies.
All right, let me see. Yes, yes, Mr. Odhikari. Other matters? Yes, Mr. Odhikari, how much time you will take?
My lord, from 4 to 4:30, your lordship has, my lord, given me time.
All right. অন্যগুলো
My lord, your lordship will kindly take pain to go through page 20, my lord, annexure A. Annexure A, my lord, first paragraph.
Yes.
First paragraph. There it is, my lord. Some overwriting are there. Your lordship will kindly see 10,19,90,000 was the initial one, and thereafter it has been, my lord, that there is some overwriting, and it has been written just below there 10,71,000. Therefore, my lord, our case is, my lord, that if there is already an agreement, and that is to the tune of rupees 10,71,000 in presence of both sides, as well as it's in the form of under Satyameva Jayate. That means your lordship kindly say under the means Ashok Stambho.
Yes.
Then, my lord, the memorandum of term loan of agreement for home loan granted to public. Therefore, my lord, it's a public document. And my lord, that there it appears, my lord, they cannot deny it because they have never denied it, that it is 10,71,000. Now, my lord, it is 10,71,000 instead of 10,99,000. This is the dispute. That means you have shown to me that it is 10,71,000. You have already made the statement of accounts as 10,71,000. Now you are raising the dispute, it is such, and whether NPA does attract or not. Now your lordship will kindly, my lord, on the next page, page 21, your lordship will kindly take time to see it. My lord, it was, my lord, in the just second paragraph, B, my lord, that the column B, my lord, that the second line, rupees 11,979, it was cut and it has been written down in the fashion.
Which page?
My lord, at page 21, just immediately the next page, my lord.
Yes.
Page 21. Page 20, I have started that 10,71,000, and now, my lord, it has stated, my lord, at page 21, my lord, that the second paragraph, we shall repay the amount of loan as per arrangement or sanction letter, which forms part of this agreement in equated monthly installments of rupees 11,673. After cutting the very particular amount, 11,979. My lord, had it been, my lord, that the 11,000 means 10,99,000, then it would have been equal monthly installment would have been 11,979. But it was, my lord, fixed by and between the parties that it would have been means 11,673, and we are paying it since last 13 years. Therefore, and why we are saying that means that the how section 13(2), that means that NPA, whether it can be turned or not. Now, your lordship, kindly take time to go through page 23. Immediately, my lord, just one page after, my lord, 22 and 23, my lord, just 23. My lord, there it has been, my lord, it is stated in this way: deed of undertaking in respect of housing for the public, housing loans for the public. The deed of undertaking made this 15th day of March 2008 by Sri Proceedings, my lord, the petitioner. And my lord, service, and my lord, this is such
My lord, thereafter, my lord, it is written in the second paragraph, whereas the borrower has applied for a housing loan of 10,71,000. My lord, has it or lordship got it? 10,71,000. And my lord, and whereas one of the terms and condition is that the said term loan of rupees 10,71,000, such and such, such and such. Therefore, here is also clear, that means it is 10,71,000. Therefore, in this page 23 also, in their self-assertion, and my lord, that they have also affirmed it that it is 23, and they have put their signature on the next page. At page 24, they have put their signature, and we have also put their signature. They were by and between the parties in the page. It's a public document, my lord. My lord will kindly take turn to page 25. My lord, there it is also, my lord, some overwritings are appearing at paragraph number 3. My lord, it is the deed of undertaking made on 15/3/2008. My lord, here it is, my lord, and whereas the bank has sanctioned a home loan of, my lord, there is again, my lord, 10,71,000 handwritten. Yes. And my lord, that it is 11,673. Therefore, there is no doubt at all that it is by and between the 10,71,000. The dispute is they are saying 10,99,000. And my lord, Mr. Shah, on the last occasion, my lord, that well, it may be 10,71,000, it may be 10,99,000, how it is, but how it can be? Because that it was such, you put it in your mind, and you have done all the evils, and it's a fraudulent act or not. For that end, this court has got entire jurisdiction on this, because the fraud vitiates everything. This honorable court has given ample power to see if there is a public authority, if you do it, then court can suo motu take exercise of the power, at least so that there is no infiltration, no intransparency in the judicial activities. Otherwise, the stream of justice will, my lord, will be clouded. Therefore, my lord, this is such. Now, my lord, paragraph, my lord, in the next page, my lord, it is again, my lord, under the seal of the government, also 26, my lord. There it is, your lordship will kindly see. Again, my lord, it is at paragraph 3, my lord, it is appearing. That means that in order to purchase the same, apply the State Bank of India for a loan of 10,71,000. And it is also in written, my lord, in writing, my lord, 10,71,000 only. My lord, it is such. Therefore, it is 10,71,000 at page 26 also, my lord. Now, my lord, the next page, my lord, page 27, under the same seal of the government, under the Ashok Stambha, my lord, here it is clear that this is such and such. Here it is also again appearing, my lord, at paragraph 4, my lord, that 10,71,000. My lord, it is there, my lord. I think that there is 10,71,000 at page 27 also. My lord, at the next page, my lord, 28, my lord, they have not denied it as yet. They have not given, they are even a one page of short note, it is expected and deserved from them, because when it's a factual matter and when it's a long-standing dispute, at least before this honorable court, and this honorable court, my lord, orally, my lord, taken orally, my lord, then that yes, you do accordingly and don't do anything, means perverse to the law. My lord, it is again, my lord, at page 28, my lord, again, my lord, at the first paragraph, my lord, in consideration of the advance of rupees 10,71,000, my lord, it is their paper, my lord, it is there. And my lord, that we have put our signature, and it is also there. And my lord, the property description is here, the same property for which I am here. Therefore, 10,71,000 at page 28 also, it is appearing. Now, my lord, page 29, my lord, here also, my lord, it is appearing 10,99,000 has been overwritten, and it has been in writing, my lord, in ink it is written 10,71,000. My lord, it is page 29 also. Now, my lord, on the next page, it is such. Now, my lord, your lordship, kindly see. Page 32, my lord, the next page. Receipt of the post-dated checks. My lord, the system at that relevant point of time, means at 2008, there was no electronic ECS system, there was not. In these days, if I buy a car, if I have had a headache, then I give that, means, well, you take it from the bank, it is not required, there is no question of delay. In those days, your lordship possibly remember, and my lord, that your lordship was adorning also a member of the bar, my lord, your lordship has got first experience in this. They are saying that this court has got no jurisdiction. Why this court? This court has got ample jurisdiction, because the constitutional power is unfettered power. At any point of time, court can suo motu exercise your lordship's power. Therefore, by simple means rather, which is a distinguishable fact, it will bring it, yes. I will not definitely, I will instruct my client, you come here, you go to civil suit also because your lawsuit is well aware. That means that the JB Partiwala in that very detailed judgment in Central Devi, Bank of India versus Pova Devi. That means that even section 34 or section 70 of the Subtenancy Act is not a bar, because that means that if there is something more, it is a very narrow, pedantic, critical jurisdiction which the Bank Subtenancy Act hold, and the officers adorning those high seats as the member or the officers, they have limited power, but the Honorable High Court's power cannot be curtailed. It's the constitutional power, and the constitutional authority there is no doubt. There cannot be thought at this. My lord, at that relevant point of time, the bunches of post-dated checks are already given to them to their satisfaction. And my lord, this indicates at page 32, that means immediately on the next page of all these transactions at the rate of 10,71,000. And my lord, your lordship will kindly see 11,673. Your lordship will kindly see second line for rupees 11,673. Therefore, my lord, that this is the system, they have accepted it, and it was continuing. And my lord, that all these check numbers, my lord, here we have given 22,110 to 22,1110. Means it is the total of 2010, 2008, 2009 in the similar matter they have taken. Just for instance, we have annexed this one, this will suffice. Even your lordship will kindly see next page, paragraph, next page, page 33, your lordship kindly take time to go through. My lord, received post-dated checks. It is Bharatiya State Bank of India. My lord, it has given in this way. Received post-dated checks for rupees 11,673 each. Therefore, they have admitted it, and my lord, that there is no dispute regarding that. This is the monthly check, and this is they are entitled to take, and we are under liability to pay. Therefore, my lord, it is such. Therefore, my lord, now my lord, the total amount 10,71,000, and my lord 11,673. Now your lordship will kindly see that these in the next page also. It is clear that how we have cash deposit we have made, and we have given it to satisfy that yes, this is the amount. Now page 35 also the same amount. That means the monthly amount. What I am to pay EMI. Now my lord, very important. My lord, page 36. This is the very important, because here is the ECS system. The ECS system in the instant case, the ECS system has been started, and the State Bank of India, like all other cases, even this very particular individual, the petitioner before your lordship, my lord, who is at your lordship's feet to get justice, my lord, there, my lord, when the ECS system comes at page 36, it is there, and it is according to them that I have accordingly advised the State Bank of India is authorized provider to raise debits on my above account regularly every month through the ECS. It is the last, my lord, paragraph.
Yes.
Amount of rupees 11,673. Therefore, my lord, this is the ECS system. My lord, because of this system, nobody feels disturbed. They will get it. Therefore, no question of at least any debit or any credit division. No extra charges be required. Nothing should be, because there is no problem. There should not be any charge, and means interest, compatible interest. In this way, he will calculate 5 lakhs, and after it, and he will occupy the premises, and he will say that now police is here. At least I am paying it, and he give me of this. What is this? These officers must have to penalize. Otherwise, I would not have come. Your lordship can see. Therefore, when at their own volition, at their own paper, and there is by and between the parties, the ECS system started on, and from that, no question of any, means if I pay, if I do not pay, then 13.2 will definitely come into operation, or 13.3 will come into operation, or thereafter all these things. NPA, when you are doing NPA, after completion of all of my dues, after 15 years, the tenure, means the total period. Kindly see this one. That means they have to, first of all, they have to prove to the satisfaction of this court, this honorable court's concern, that it is a easy to fit case for NPA. NPA means what? 15 years tenure. At least 2 years, 3 years, and they are not paying regularly. This is such, then it is. After completion of entire one, you are raising the plea that there is NPA, there was such, and therefore that we will procure property, and in this way we will do. Is it not a threat to the public? Is it not a threat by the public institution, at least to the ordinary citizen of the country who is trying to live peacefully with his little income, with his family consisting of such? My lord, to be very proud that today I am happy to hear that I am, my lord, taking the brief of such a person. That means that whose only daughter, she has secured 96.5 or 6 marks. Therefore, that if the society will not develop, my lord, if your lordships would not have developed, we would be scattered in that. Therefore, the court will have to see all these things, the disputed facts and circumstances. When the honorable court will see, that means that, well, these officers, for their own reason, with perverted mind, they have taken some action which is not permissible in law, and they are doing all injustice to a person who has already completed or all intention to complete it, and thereafter he is suffering that, means NPA. Is it not a fraud on court? Therefore, that this is the particular page 36 is the main paragraph where ECS system starts. Now your lordship kindly see. Thereafter page 37, my lord, that the again, my lord, that the again we are returning to it to show page 37, your lordship, 11,673, and it is 2010 to 2012 beforehand. Before this, we have already cleared. Therefore, they are satisfied. Then, my lord, therefore, my lord, that the page 36 had arisen, had come into picture. Therefore, there is no doubt at all. Therefore, in 37, if they are to admit that everything before the ECS, therefore they got it, that means that everything in time and everything is over, then definitely they could not have come with this allegation that it is a NPA. At least, my lord, that before the ECS, my lord, starting of ECS, it becomes clear to this honorable court, there cannot be any doubt that there must have to be some, means failure on the part of either paying the reasonable interest or paying the principal sum to the bank, which he is legally obliged to do. It is by and between the parties, because page 36 is the main page where it is located, and 37 is the clearing one that after it is been done. Therefore, it is done in this manner. Then your lordship kindly see page 38. My lord, kindly see, there it is written in this way. There again, my lord, it is appearing 4-paid EMI amount 11,673. If it is so, then my lord, your lordship, if your lordship will kindly see, therefore there is no doubt that this is 11,673. It has not been changed or altered at any point of time. But I will show statement of account how they have committed blunder. Now, your lordship, for your lordship's perusal, that means we have again given 11,673 to, means rather to substantiate our claim with all these papers at page 39 also. It is clear that 11,673 is the admitted amount which I am to pay every month. Now, my lord, this is the vital one. My lord, kindly, it is the PDF one. This is there. My lord, that the PDF in this way, how your lordship kindly see, page 41. What is this statement of account? This is the main thing. After considering all these factual aspects, and admittedly not disputed by them, not even by writing, they have made any whisper regarding it. And the sanctity and wisdom of Mr. Saha is definitely above everything, because as a friend of mine, I have every respect for the other side. But I think that means that my client, if be some on the wrong footing, it is my pardon duty, which we have learned at the 772 years. That means that after covering 45 years, that we should not give a shield to them, because that otherwise that we will suffer. There is, means rather, because it is next to court. We are before this, we are getting this chance before your lordship. Your lordships, we are before the honorable court's feet, so that there will be no natural justice will flout it. They could have decided it. We would not have proceeded before the court. But they have done it because government's money, your lordship is well aware, even the Supreme Court, even different high courts, that the misuse of the money, how the government, that means that to spend all these things to do all this is a pretty pressure on the psychological pressure, economic pressure, etc. This statement of account, definitely it is therein. When they have given, my lord, when I was insisting I did not like to disturb your lordship, therefore in a cut short matter we have to say. There are a series of all these, my lord, that every time I were in communication with it, Gmail, because my client is also, and my lord, that the noble citizen, and my lord, that he is a, my lord, that he abides by the law. This is the most important page 741, statement of account. Here it is, they have given only on 13/4/2023. Now, kindly, your lordship possibly remember that the 2008 it has started. Now, after 15 years, 23, they have given it only after 15 years on 13/4/2023. I am intending to speak through this, my lord, that they are for the first time, they are giving this statement of account, and there the anomalies are found. Now, your lordship, kindly see, cleared balance, date 13/4/2023. 4,67,000 such and such, limit 10,99,000. Kindly have a look, my lord, 10,99,000. How it could be? How it could be limit 10,99,000? Therefore, insertion in the statement of account for the first time from 10,71,000 to 10,99,000, whether does not make a heaven difference or hell difference. I am asking to my conscience, my lord. I am before the lordship, my lord. I am definitely, my lord, proud of your lordship, my lord. Basically, fundamentally, my lord. And your lordship is here, my lord. We are at your lordship's feet to see. Therefore, my lord, how it is? Is it not painful? After it, you are first disclosed in 10,99,000. Now, kindly have a look, my lord, that if it is such, then definitely they are entitled to get it. If it is 10,99,000, imagine, my lord, that in a rent case, my lord, I have advised my client, my child, my daughter is also, my lord, because of the heavy grace of your lordships, my lord, I am told that yes, you pay from 1993, and my lord, that when 43,000 is the principal sum, total amount with 10% interest, it comes to 1,80,000, 79,000 is such. Imagine, but I told that yes, try to do it for you, at least to keep you in a safe position so that there is no headache. Well, look, if in 10,99,000, if it would be from 2008, first disclosed on 13/4, my lord, they have not shown any paper 2023. There will be definitely NPA, and NPA, not which is not directly possible, in the indirect way, can it be made possible? Therefore, why the High Court will be powerless to see all these things? Is it not a fundamental defect? My constitutional right, though, my lord, that my right has been, my lord, that from fundamental right to property, my lord, that the Article 31, it has been shifted to Article 301A. But, my lord, that in series of judgments, my lord, that does not necessarily mean, but the right to property is also, it will be, it amounts to fundamental right. And, my lord, if my fundamental right is going to be jeopardized, because the home loan, government is patronizing. The government policy is at least so that there will be every man, every citizen has a home for his family. This is because of the global policy. And my lord, you are doing all this nonsense to all these common people. If this is if he's a serious citizen, my lord, if it is serious, if he is suffering, kindly, my lord, your lordship can imagine, my lord, these amount, if they will be able to take, my lord, somehow in some negative way, my lord, from the parties, then, my lord, they are successful. If they not, and my lord, that this will be for some years, maybe 10 years, 12 years, or 7 years, maybe more. But thereafter, my lord, they will distribute among themselves. This is the, my lord, inner history. That, my lord, I have, my lord, that this is the another chapter. Now, my lord, if your lordship kindly see, now I have before your lordship, I have already, my lord, the chartered accountant. My lord, your lordship is well aware. My lord, chartered accountant, my lord, prima facie, at least that they enlighten over all these things. They have given all the arithmetical calculation. Means, therefore, my client, my lord, with his ordinary intelligence, he approached to the CA's report. And my lord, with all bona fide, my lord, I have proceeded before your lordship. On the last date, my junior has submitted, my lord, this. Kindly, your lordship will kindly see. My lord, has your lordship got, my lord, that very particular CA's report? My lord, page 41. Now, my lord, page 41, my lord, it is in PDF form. But my lord, in CS report, my lord, we have made an enhanced form because in PDF.
Copy of that.
You take it. Yes, this is the copy. And my lord, that is because my lord, it is so short version PDF at page 41, it could not be understood. Therefore, my lord, we have stated, my lord, at page 41, and there is no wrong, my lord. I have already compared. In page, my lord, 41, what it is stated, sanctioned by RACP. My lord, 10,71,000. At page 41 of the writ petition, my lord has got that the 10,71,000, 23/3/2008 sanctioned amount. My lord, 10,71,000. But my lord, I have already shown to your lordship that limit 10,99,000. Therefore, there is the, my lord, self-controversy. My lord, that is 10,99,000, they have stated that 10,71,000. Now, my lord, in the CA report, my lord, in the same thing, because it is only in the, means rather in the better form, in the better version. In the better way, 10,71,000, it is made, my lord, clear on 24/3/2008. My lord, there is also 10,71,000. Now, my lord, it is going, and page 41, my lord, there, my lord, your lordship will kindly see 16/6/2008. And now, my lord, your lordship will compare to the, my lord, the data which I am placing in the CS report, 16/6/2008. In the PDF form, 16/6/2008, single-sided advance, 27,895. This is the intrusion. Now, imagine your lordship. My lord, it is not beyond my knowledge. You have accepted everything. You have included 27,895 as the debit. Which account? Can you do? If everything is closed, what I have seen, matter ends there. Judge, there are a series of judgments I don't like because your lordship is well aware. Your lordship has got that very particular power, God-given power. I am saying we are proud of it, my lord. That you cannot change and alter. Nobody cannot change. It is the basic principle of the contract. Even whoever he may be, he can't. No, my lord, that when 10,71,000 it is closed, then why you have put 27,895, and it has been broadly, my lord, it has been given. Copy also has been given to him, my dear friends. I have already given copy. There it is, my lord, single-sided advance. How they will explain? Let them explain that what is the meaning of single-sided advance? Because that I am not taking any money. The landlord is selling the property. The flat is sold. You are paying the bank. You are being satisfied. I am nobody. I am to enjoy, and every month I am to keep. Now, whom you have paid this advance? My lord, in CS report, it will be clear. Now, if it will be so, then, my lord, that whether there will be no the basic and fundamental, let them say, let them explain, my lord. If they will explain by a single piece of paper, my lord, they will face perjury, my lord. My lord, your lordship is well aware in my lord that the Sarvapalli Radhakrishnan's case, my lord, that the Honorable Justice E.V. Lalit, my lord, that it has been said that is well, even after the completion of it, that the court will find that there is such, then the court will find perjury. They are saying, no, go to appeal court. Why not you are filing it? Out of your sanctity and wisdom. You are the bank officers. You have to explain it. You have given it. You have given you that very particular C41. You have given your statement of account. How you have written 10,99,000 and you have expressed it, say 10,71, the initial one. You have taken money on the basis of it. You have done everything. All the checks are there. How it could be an NPA? And how you can include 27,000? Is it your duty to explain? Because the statement of account given to you, keeping me in that. Maybe that in those days it is not possible in the digital system that was not so advanced in those days. It was not possible for you at least to give all the statement of accounts. And at least on the verge of the completion of all the entire borrowings amount, or rather what you have taken or not, then you have come to the conclusion that now it is the fifth time that you have given a statement of account. Then for the first time I have come to know that it is on that very time you have taken this. What is the meaning of it? Single-sided advance. Single-sided advance. Single-sided advance, so far, my lord, that I have tried my level best to find it out. That the single-sided advance means one side, he gives advance without the express consent or implied consent of the other side, and your lordship, it is the common meaning. Therefore, if I do it, if I am not taking the advance, how you have? Because for the purpose of raising your NPA to make it NPA. Is it not a fraud on the institution? Being the means rather the cherished, my lord, institution, you are holding this important position. You are the authorized officer.
Have a copy of your SURFACE application.
My lord, SURFACE application, my lord, very painful, my lord. In SURFACE, what happens, my lord? There is a, my lord, system. These people, they are given, that means by post.
I am also not having a copy of the SURFACE application.
Give it to him also.
He let him take. He knows, my lord, that the bank's officers should not say all these things. Otherwise, he is nothing. You will also kindly see, though it is poorly drafted, let them say, because, my lord, that what happens in bank cases, the people, they get advance notice from the bank. They now send a telephonic call and they say that send and come to us. We will file, we will give you relief. This is the position. And my lord, their man, they do it. And my lord, that thereafter, my lord, they make poor drafting, even if in the poor drafting section 17A, though it has not been clarified. Therefore, my lord, your lordship is well aware that for the laches of the advocates, or maybe for it, the clients should not suffer. Therefore, it is not such. Now, your lordship, kindly see, there it is ECS. After the ECS, kindly have a look, my lord. After ECS, my lord, that it is according to their, my lord, their page number, that means Annexure C. If your lordship will kindly see 6/2/2015. There is ECS. 2015, 12/7/2015. And 12/2/2015. My lord, there is debit adjustment 25,562 and 562. They have debited this amount. What is this amount? If the ECS system is already in operation, you are doing all these things, how 562 I am to pay? And it is the compounding interest. My lord, we are in a very faithful state, my lord, because that we are entrusting the banks. We are doing our job, legal jobs. We are doing our professional jobs, and they do all these things. This is their research. That means to put in this way and to give trouble. If somebody else will not see, supposing my client would not have seen because that he was not careful at all. But when I have taken the brief that yes, I will take up the matter and I will go before the Honorable Court, because the Honorable Court sanctity and wisdom is undoubtedly, my lord, that is of, my lord, that the super class. My lord, therefore, my lord, it is therefore the after ECS, whether there can be any, my lord, interest in this way. 562, and 25. It is such. Now your lordship will kindly see, very important. It is there, 26/5/2014. I'm not taking pain, at least I'm not, I am giving pain. That means where their statement of account here there is stated, but where it is my broadened version is there, 26/5/2004. There is again, there is written, kindly have a look to their statement of account. My lord, 26/5/2014. I've given it, my lord, in some mark. 26/5/2014. Debit adjustment SBI General Insurance Premium paid. And the same page below what I have stated. My lord, 3,520. Debit adjustment SBI General Insurance Premium paid. When there is it general insurance, you are imposing something to which I have got no consent, and it was, you have already cut it 10,99,000, and you have given me that, because according to the Reserve Bank guideline, it is an optional one. A man, a poor man, who is trying at least to give education to his children, he will say that I am on the God, let me survive. Why do insurance? If I can getting this, if I am to pay every month, then it is sufficient. If it will go, then what will be? But God will take from my lord. That I am saying, my lord, your lordship can listen. My lord, if my lord, your lordship is convinced by 1 minute, then I should not say. And if your lordship, my lord, if my lord, that I think this should have been, my lord, that there would have been complete end of this episode had they, my lord, out of their sanctity, put a written objection, because whatever may be, I have filed a written petition. That writ petition was taken up for hearing. And my lord, on the hearing thereafter judgment, without their, my lord, that they are making oral submission. Oral submission, my lord, has been, my lord, that is thwarted by it. Why not, my lord? Kindly, my lord, it would have been very common, my lord, had they, my lord, that if they will file at least that one page.
That is according to him.
My lord, if
They do not choose to file the opposition.
they will suffer the consequence. Law is very much clear, and even their right of audience also, my lord, cannot be taken.
So please
My lord,
concentrate on
my
the
lord,
impugned order.
my lord, yes. Now your lordship kindly see, my lord, thereafter, my lord, I am to go, my lord. After it, kindly take pen, my lord. After it, my lord, your lordship, therefore, the statement of accounts, it is from 41 to page 64. My lord, I am saying,
That is that I cannot go to all those facts.
No, my lord, it is.
Only the difficulty is because.
My lord, page 64, my lord. My lord, only to the limited extent, my lord, I am making. My lord, page 65.
Because all those accounts I cannot go into.
No, my lord, it is true. It is true. But my lord, ex-face, if your lordship will find, and it is then. Then, my lord, they are explainable. If they are not explainable, then, my lord, I have shown. And, my lord, page 65, kindly, my page 65, my lord. They are, your lordship, kindly see.
Yes, I have seen.
My lord, with reference to turnover of 10 lakh.
That is 10 lakh 71.
No, my lord, not only that. They are, my lord, that they are on 6/5/2014. They have asked for an option. You are requested to arrange to insure the property immediately with a general insurance of your choice. If not already done, therefore it was not done. If not already done means they are also not sure it has been done. Therefore, up to that period, 6/5, up to 5/5/2014, there was no insurance according to them. Therefore, if after 6 years, when I have not taken admittedly that the insurance, then they have included it. Just immediately after 4 months, they have included 27,000. Thereafter, they have first disclosed it is such. Whether when they have opted from us 6 years, after 6 years, I will not get the senior government. After 6 years, I'll be dead. When 6 years I could cover by the grace of the God, I can definitely cover what. Therefore, that whether this is a 6/5/14, it is helpful for this case. Therefore, that when you have put at the general premium, insurance premium, therefore you have taken on this beforehand. When you are taking instruction from me whether I am means intending to take insurance or not, this 65 page, my lord, Annexure D is the vital one. And my lord, that from our records, if not already done, and forward the original policy document for our records. Please note that if the same is not received by us within 10 days from the date of receipt of this letter, we will be constrained to take insurance policy with adequate cover for estate. Whether is it possible? You can unilaterally can impose. Therefore, my lord, if we will be constrained to take insurance policy with adequate cover for SCI General Insurance Company Limited as per terms and condition of the loan agreement by debiting your loan account with the premium payable. Therefore, it is an afterthought process or not. Therefore, you are constraining me to take it, and I have not opted. And my lord, they cannot show any paper that afterward we have means are opted. Therefore, you are imposing me something. Even if you will impose, you cannot means rather antedated. You will have to do it post-dated. Law is also very much clear. That means that you are means can do anything on 14. Even if you can't do, because when the contract is complete, it is a concluded contract. My lord has come from the civil, well, generation after generation, your lordships have come. When it is a contract, a concluded contract, and my lord, there is series of judgment. After it, whether they can reopen it in 2016, after 14, after it, therefore it is the most important one. Now, your lordship kindly see, my lord, I am coming. NPA. Now, NPA, what is the date? Now, my lord, kindly see, when there was already completion of all my dates, and my lord, when I have found that already in the civil record, I'm a good one. I'm a good citizen, I'm paying. Therefore, my lord, 8/12/2023. Kindly page 66, my lord. 8/12/2023, my lord. Notice under section 13(2) of the Securitization Act. My lord, the book is with me. I do not consume the valuable times of your lordship. Notice under section when? 8/12/2023. Can you do it? Knowing fully well that I am always in the regular one, and my lord, that from all these records it is clear. That means in this way we are paid every time, every month, every way, and there is so that there is no some bad will. And my generation is also waiting at least that to have advanced studies and also to take loan from the banks. Then it is such. Therefore, my lord, is it, my lord, tenable in the eye of the law? My lord, is it a narrow pedantic people jurisdiction holder that single tribunal can do? My lord, even if they do, they will not. Because if they will do, then, my lord, everything will come out. And the High Court, my lord, the omnipotent power holder, my lord, that will come. Therefore, my lord, if your lordship kindly see, it is a redundant exercise. The NPA itself is bad. My,
You want to cite any decision?
my lord, if your lordship will ask for any decision, my lord, that I may place. But my lord, wait a minute. But my lord, that here, my lord, the law is very much clear. Your lordship is well aware. My lord, that the violation of the natural justice, if I can prove, though it is a negative judgment, another High Court judgment, and my lord, that if your lordship will kindly see the latest judgment of Honorable Supreme Court through Honorable Justice Paddiwala and Honorable Company and Justice, there it is. There it is stated that the even civil suit is permissible. My lord, if civil suit is permissible, High Court is because that means that the other one it is. If your lordship kindly take, it is only one copy, my lord. It is for your lordship. And some pencil marks at least in the 2 or 3 pages. My lord, that is the
which paragraph?
Paragraph, my lord, the first some paragraphs kindly see, my lord, and ultimate last paragraph also, page 45. Citation is Central Bank of India versus A. And my lord, there, my lord, here it is in this case, actually, my lord, this was the case. And last paragraph, and also first paragraph, the pencil marks are there. Some paragraphs there it is. That means it is distinguished in this way, 34 and 17. That means that there, my lord, that they proceeded, they was raising the dispute. That means the civil suit is not permissible. Then they filed the plaint, rejection of the plaint. Then the party, that means that no, it is my property. How the bank can do it? If you do it, then it is definitely it is against the law. Then he filed a civil case. Bank came. Bank told that no, it is not order 7 rule 11.
56, it has been held.
And my lord, and the last paragraph also, my lord, that yes, my lord. My lord, your lordship is well versed. Now, my lord, kindly.
Yes, please note this.
And my lord, that his judgment he has not even given to me.
It's not my judgment, Supreme Court.
No, so your judgment means what you have placed on the last date. My lord, without it, I am doing. My junior
has given citations. There has to.
No, my lord, the junior could not catch it because that there was communication gap. He was thinking.
Junior was here.
My junior was here, but my lord, that it was duty that when juniors are there, if had it been his juniors, it is my duty to give one copy, also keeping it that well it is. But my lord, that Saha should do, but Saha did not do all these things. Maybe because he is Saha, we are all means Saha. That is the entire problem. He is above us. My lord, the problem is, my lord, that it is true that this very limited power.
His submission that even civil suits are maintainable. Article 226.
Not only that, my lord, that had it been so, my lord, when your lordship fixed the date, then my lord Aurobindo Chatterjee was there and Subtenancy Bose was there. 30 crores. Then I came and your lordship told, yes, Mr. Odhikari, when to be fixed. Then my lord, then all these cases would not have come to it. It may be because that means that if Honorable Court will take the decision in this case, then this court has got no jurisdiction. You go to appeal forum, whether it will not be a punitive measure. Kindly see, because appeal forum is a forum which has a very limited jurisdiction. What order has been passed, generally they do not go against it. If they would have done, then the Honorable Supreme Court could not have taken the note of all these things, that the other forums also there, all these things are there. Therefore, if all these thoughts are there, then this Honorable Court can do one thing. This Honorable Court may direct, yes, Mr. Saha, ask your client not to take poison. I am sending it, at least that if that be so, under the direction of the Honorable High Court, they can do. That means that at least 3 months or such month, whatever month they will take, they will stop every action. And my lord, that I am not leaving everything because that it is such, their NPA itself is that all things will be taken note of by the concerned court, and they will, or your lordship may do that it means rather you give 1 page judgment or 1 page your AO, so that whether if there is perjurious action, because I can catch him, because your lordship kindly see, in perjury one thing is required. If he gives everything on affidavit, maybe false or such, then my lord, it comes within the grip of perjury. And my lord, perjury has no time. Now your lordship kindly see, Jyoti versus State of Punjab. They are also, my lord, principle of natural justice. Unfortunately, in this case, though petitioner has been defeated in that case by the, my lord, Punjab High Court on the principle that the learned counsel for the petitioner has not been able to show any jurisdictional error as exercised by the DRT while passing the impugned order. Even the argument of the learned counsel for the petitioner that there has been violation of principle of natural justice is not made out in the present case. The judgment relied upon by the learned counsel for the petitioner in the case of such, it is distinguished of fact. But therefore, but we have been able,
On principle, your contention has been accepted.
my principle of natural justice, because that the how it is, how the section 13(2) at the far end, at the far end, let them prove that is whether it can be done or not.
All right.
It is my signature. And now, my lord, you will also kindly see, though, my lord, the law is very much clear and specific. My lord, Article 227 is permissible. My lord, your lordship, I don't like to disturb your lordship because your lordship is, my lord, is for us. So many cases before vacation. My lord, that the Article 226, Baburam, Prakash, Chandra, Maheshwari, my lord, it is, your lordship knows that they are 1969 SC. Now, Whirlpool Corporation's case, your lordship is well aware. There, if your lordship will demand it, then, my lord, that I am to ask my junior at least to get it Xerox and to. My lord, they are.
Whirlpool, I think, covers
everything. I am grateful. There, my lord,
Whirlpool's
Article
judgment,
227 is permissible if there is significant jurisdictional error, if there is violation of fundamental right, other exceptional circumstances where the statutory appeal process is inadequate. My lord, Whirlpool's case.
Whirlpool's judgment, I think.
Whirlpool's case. That's my lord, that is. Therefore, my lord, that the very limited scope which the appeal court hold, my lord, that your lordship came from the civil bench, it is not. My lord, kindly, my lord, that thereafter, your lordship kindly see, I have already shown your lordship that it is not, my lord, that the NPA is not permissible, and my lord, that my lord has not been taken. My lord, the most important thing your lordship will kindly see, and is now your lordship is saying that what is the impugned order. My lord, in between, my lord, there are some detailing, my lord, that the after
not going into those details.
Details. And my lord, your lordship will kindly see. Now your lordship will kindly see. There are all these in the get details are there. Now, my lord, here, my lord, the most important thing at page 92. My lord, how I am suffered and how my case has been page 92, my lord.
All right.
Page 92. My lord, how it has been brought to the notice of the, my lord, rule 129 of the record manual. My lord, it starts. Now, it is the order sheet dated such and such. Nature of the case, my lord, such and such. Name of the such and such. Name of the respondent, such and such. My lord, here your lordship, here is written, my lord, the last and, my lord, first paragraph, second paragraph, third paragraph. Your lordship kindly see.
1099.
Not 1099.
Yes, I've seen.
Therefore, my lord, the entire exercise on the part of the police authority, on the part
because it's 1071.
1071. Had it been so, then it is such. My lord, what I am saying, my lord, here and now, my lord, or not, man, any day, my lord, that I am not, my lord, in such a position, my lord, because my family, my lord, is always in a trouble.
I will consider, so give me only Whirlpool's judgment because I think that.
And my lord, that even if your lordship, my lord, that here and now, even if, my lord, your lordship will, my lord, that charge that, well, Mr. Odhikari, here and now will pay, my lord, within a stipulated day, my lord, that we will pay it, my lord, but it is not such a case that they are the fag end of my right. Supposing, my lord, if Mr. Vijay Odhikari will be charged a criminal case, murder case, or rape case, at the fag end of the life, then, my lord, it is the sorrowful case. That means that I have covered my 72, my lord, that the seasons here in this 72.
Right. Yes, Mr. Shah.
My lord, there were 10,99,000.
2003, volume 3, SCC 185. Whirlpool.
2003, volume 3,
SCC.
It is not applicable, distinguishable.
2003.
2000, no, my lord, 2000, volume 3. Year 2000, volume 3, SCC. Probably, my lord, this is not the one. No, my lord. 1998, volume 8, SCC 1.
Yes. This is what judgment?
This is Whirlpool.
Yes, yes.
My lord, it says that
he is relying upon.
My lord, the case is, my lord, here is, the matter is that what my lord Planet Fund is pointing out that we have made a the representation before the DA was not properly made. It was said that 10,99,000 was the sanction amount. My lord, initially the sanction amount was 10,99,000, but disbursed 10,71,000.
How?
My lord,
how it is. My lord, let it be reported, my lord. Otherwise, my lord, that the let video clipping, my lord, sanction amount, it is a vital one. My lord,
My lord,
he is saying.
kindly appreciate one thing, my lord. The DM is not an adjudicatory body. The DM under exercising powers under section 14 of the Surface Act, my lord, is only functioning as a ministerial function. Only he has to see that whether 13.2 has been delivered or not, whether 13.2 has been delivered, affixed, published or not, whether the procedures that are prescribed under the law has been fulfilled or not, complied with or not. That is the only lookout for the DM. DM is not supposed to adjudicate whether it is 11 lakh or 10 lakh, or what is the rate of interest, why this has been charged,
they do take chance.
why the outstanding is such and such and not this. DM is not here to adjudicate, my lord. In this respect, I am not armed with the decision. It is a very well-known decision of our Honorable High Court, my lord. Johar Singh's case, my lord.
Johar Singh case. Johar Singh case on another fact.
The role of the DM, it is perhaps the first judgment of our Honorable High Court which spells out the role of DM exercising power under section 14.
What is the site, sir?
My lord, 2015, year 2015, Calcutta, 306.
All right. Anything more, Mr. Shah?
Yeah, it is distinguishable.
My lord, the scope of this civil application, revisional application is impugning the order passed by the DRT while disposing an interim application. The essay is pending, all these issues are pending.
In reply to it, my lord, that means that they are saying that the order of the learned tribunal at page 92. Page 92, my lord, kindly have a look. My lord, how he has decided the matter. Page 68, first of all, page 68, my lord, in reply. Page 68, at least for a moment. Your lordship has seen page 65 and page 68. Page 68, amount secured, sanction letter, amount secured 10,99,000. Sanction letter, deed of undertaking 10,99,000. Therefore, deed of undertaking, it is a totally fraud. It is totally fraud. Totally fraud because you are exposing it for the first time, 10,99,000, you are saying it. Therefore, it is page 68. If your lordship will kindly see the order, my lord, what I am coming to is, my lord, the order, IA, my lord, maybe it is interim application. Yes, it is true. But the interim application, if causes some such serious, which is as like the adjudicating the entire case, that case no remains at all. It will be outstayed. There will be a lot of problem with family. I am to go out. What will be my position? My lord, can they imagine? That means if I will be in the field, then my lord, what would be the fate of the officers? Because, my lord, because I am in tempered position there, what will be my future? Because it's you also can see in filing this petition, surface application IA, they have decided it casually. Impugned order dated 2/8/24 passed by the learned district magistrate South Chowbish Pargana. It is stated that purported order dated 2/8/24 is bad in law. It is stated, we have stated. It is also alleged that learned DM has passed the order without application of mine. Because 10,99,000, had it been, the DM has took note of it, whether it is 10,71,000, whether it is already Surface Act terms or not, but DM has like a post office he has acted. It is also stated that learned DM has not recorded in the impugned order about the deposits made by the Surface applicant after 13.2 notice. Yes, also all these anomalies, we have brought it to the notice of the learned tribunal. What is duty then to decide it in this way manner? It is also alleged that learned DM has not complied with the statutory provision of the law as enumerated under various subclauses 1 to 9 of the provision such and such, has paid to stay the impugned order. Learned Counsel for Defendant Max submits that there is no such order. I have gone through the purported order dated 2/8/2024. Honorable Supreme Court, my lord, it is purely a par incurrum judgment. For it is a distinguishable judgment. It has got no application here. To hold in Standard Chartered Bank, Nobel Kumar, my lord, my case is not that. 9 subclause under the provisions are required to be furnished in the affidavit such and such. This 9. But this is one fundamental, this particular judgment does not deal with. If it is 10,71,000, then it could not have been. If it is 10,91,000, therefore, this case is generally distinguished to the facts and circumstances of our case. Therefore, but he has imported this and he has brought that so as everything is right. It appears that the learned DM South Tribunal has recorded all the 9 clauses. Therefore, his duty is over. You have been put, you being the tribunal, you are to put all these things to see that not only that you have means that the DM committed wrong or not, but what is your duty while you are disposing of the IA application by which the one particular property is going to be out of this version, and you are after this, then what will be you are as in you are doing, my lord, kindly see, my lord, that the my lord, kindly see section learned DM. It appears that the learned DM South Chowbish Pargana, learned DM is only to adjudicate. Landed DM is only to adjudicate. But what you have to do, you have to adjudicate everything under section 71, 17. You have not done your duty. You are simply saying it will be heard in the hearing. Yes, if it is at the hearing, then means expedite the hearing, and in the meantime not take any action. Now, my lord, that kindly stay as prayed for is refused. Section 14 does not contemplate adjudication. Section 14 not only there means it covers the entire Tax Recovery Tribunal or Service Act. There are other sections also. Means protection to the means rather debtor, protection to the borrower definitely is, my lord, there. And even if it is not there, then, my lord, the High Court's honorable potential power is there, at least to intervene in the matter. Do in this way, not in that way. My lord, whether this honorable court is powerless to do all these things, my lord, if that be so, my lord, that the I do not find any illegality. When it is apparent, not discussing with it, your lordship will kindly find, is there any reasoned order? Prima facie, he is coming, no illegality, no illegality.
That. Yes.
This honorable court has got ample power at least to interfere in the matter, my lord, that I am giving the judgments, my lord. If willful judgment only will not do, then the two other judgments also enter. And my lord, that if the report is there, my lord, according to them, if your lordship will please, my lord, your lordship do add me, that may I will pay the amount.
For the part.
I have to give such kind of.